How can I tell? Ask your colleague.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಕೋರ್ಟ್ ಅಲ್ಲಿ 2 ಕೋರ್ಟ್ ಅಲ್ಲಿ 3 ಮೇಡಮ್? ಕೋರ್ಟ್ ಅಲ್ಲಿ 2 ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ.
ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಹಾಲ್ ನಂಬರ್ 3 ನಾ?
ಎಲ್ಲ ಕೋರ್ಟಲ್ 3 ಅಂತ ಅನ್ಕೊಂಡಿದೀವಿ.
ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ಸ್
ಅಲ್ಲ,
ಅಮ್ಮ.
ಇದರಲ್ಲಿ
Okay.
CCH-2 ಅಂತ ಬರ್ತಾ ಇದೆ ಅದಕ್ಕೆ.
ಥ್ಯಾಂಕ್ಸ್ ಅಮ್ಮ.
Any mentioning? List one, page one, number 1 and 2. Page 2, number 3.
My lord,
Page
serial number
4.
3, my lord, appearing for appellant, my lord.
Yes.
Last date appearing, my lord, lordship directed for a compromise, my lord. They are not agreeing for compromise, my lord. Maybe taken for next week, my lord. We'll argue on merits for admission.
KSFC, the appeal
Yes, madam.
already stands dismissed as against R2.
Yeah,
Now it's
R2 is
only-
an R2 is a contesting. Is not. She is not contesting, my lord. She's
But
an wife of appellant number 1 and 2, my lord.
Therefore, appeal already stands dismissed as against R2. R2 is
R2
not
is
there
an
anymore.
No, we are not seeking any relief against R2, my lord. She is an wife of
Just
appellant
a
number
moment.
1 and 2.
Okay, okay.
So far as appellant number 2 is concerned, we purchased the property during pendency of miscellaneous.
Okay.
After decree, my lords, 50 days executed.
Okay.
Last time, lordship suggested for settlement, which we have said no. So they can argue.
So
on
now
merits.
matter has to be argued on merits.
Yes,
Yes, my lord.
After a week. After a week.
very good.
Yes, learned counsel
Date
for
may
the
fix, my lord. Any date may fix.
learned counsel appearing on either side submit that there is no chance of settlement in the matter. List on.
17 posts.
Yes.
Much obliged, my lord.
Grateful.
Page 3, 4 to 6. Page 8, 7 to 10. Page 11, 11 to 13. Page 12, till number 14. Page 13, 15 to 17. Page 15, till number 18. Page 16, till number 19. Page 17, till number 20. Page 18, 21 to 22. Page 19, 23 to 26.
Page serial number 23. I am for the
Yes.
appellant. Now I notice that there is depositions are in Kannada. I want to translate. May I have it after a week, my lord? My request to you.
23. File hearing
Yes.
matter.
Yes, yes. The depositions are also in Kannada. Incidentally, I have to translate. Kindly have it.
The appellant seeks a short accommodation to provide the translation of the depositions.
Depositions. Yes.
Yes.
Obliged.
23-4. Page 20, seal number 27 to 29. Page 21, seal number 30 to 33. Page 22, 34 to 36.
I am for respondent number, I am for respondent, my lord, serial number 34. The advocate is not feeling well. Respondent advocate is not feeling well. My lord. Kindly grant me a week time. I have come a week
Have you
time, my
informed
lord.
the other side? Have you informed the appellant?
Message through WhatsApp, my lord.
I appear for the appellant, my lord, serial number 34.
Yes. Can be on some other day
Yes,
Yeah.
my lord.
at the request of the learned counsel for the respondent list out. Please give a date.
Much obliged, sir.
16-4.
Yes.
Much obliged.
List 1, admission, seal number 1, Basuraj Patel. Rajesh Shettigar.
I appear for the appellant in the connected matter.
Athova,
Matter may be taken in next week, my lords.
why?
Counsel on record is not keeping well. Kindly next week.
When you say not to put in the yes.
It is submitted that arguing counsel is indisposed. Hence, they notify date go to it last week. Actually, nothing. In the short it go to it next week. Most be done.
9-4.
Oh my.
Much obliged.
Next week we ಮಾಡಬೇಕು ಹೇಳಿ.
2, Nagaya,
For the respondent, my learned friend is yet to provide me, my lord, a copy of the IA which he has filed. The Lordship
What
may,
is, what is the IA?
my lord,
for
for additional
documents?
document. The Lordship may direct him, my lord, I'll collect it. The Lordship may make an observation.
Yes, learned counsel for the appellant
Appellant.
shall provide copies of the IA. Copies of the IAs on the learned counsel appearing for the respondent. List after 2 weeks,
Next week, my lord, it's small matter.
covered matter.
It is single judge, my lord, it is covered.
That is also covered. Oh, single judge,
Single judge, my lord, the very same notification is covered. The Lordship may have it next week, my lord.
7. 7-4.
My lord, in serial number 2.4,
Hmm.
my lord, I serve a copy on Mr. Nagai and learned government advocate.
that is your appeal.
That is my appeal.
Yes,
My lord, IA 2 of 2024, my lord, I have filed an application, my lord, seeking permission to prosecute the matter because, my lord, the landowner was dead. They are the LRs, my lord. I have sought for leave of this honorable court.
please serve copies.
Let me serve a copy.
Yes.
My lord, last serial number 5 objection, my lord, your lordship may overrule it, my lord, because I need not deposit, my lord.
That can be overruled for the time being. Last
Please.
objection with regard to deposit of amount,
That's-
overruled for the time being.
Much.
Adjourned. Preliminary hearing, till number 4.
Serial number 4, after for the appellant's counsel, my lord. I'm ready, my lord. Shouldn't take too much time, my lord. I just.
Pass over, can we pass it over in here?
My lord, Passover is at 2:30, I have some difficulty, my lord.
It will not, normally in normal situation. it
After
does
this,
not-
yes, my lord. In case I'm not there, could your lordship accommodate me 5-10 minutes? I'll make sure I'm
Sure.
grateful.
Hearing on IA, till number 5. Ramchandra,
My offering for respondent too, my lord.
Appellant Can be allowed.
Appellant, yes. Accepting the partial, the affidavit, IA 1 or accompanied to IA 1 of 25, the same is allowed. Appellant is permitted to bring the LRs of this is appellant. Amend and appellant is, learned counsel is directed to amend the cost item. Amend the cost item.
My lords, my apologies, my lords, on submission. In serial number 2, interim order has to be extended, my lords, and for appellant,
Serial number
2,
2. You are for the,
appellant.
yes, interim order wherever there is, let me check. Remain in force.
Respondent too, my lord.
Yes, yes. Appellant is permitted to amend the cost item, like.
6. Chandrakant Argole.
I'm sorry to disturb your lordships, my lord. In this petition, that is 6.6, my lord, 15703. Now they have given NOC, my lord, for transfer. He has been studying, my lord, in 8th Respondent College, that is Shamnur Shiv Shankarappa College. Now, my lord, he is seeking transfer to Dr. Ambedkar. I'm sorry to trouble your lordships, my lord.
This is not going to end anytime soon. This has to be given a quietus.
Lord, in fact.
Which college are you now studying in?
I'm requesting for transfer to
Which college are you?
R8, my lord, R8 Shamnur Shiv Shankarappa College, Davangere.
Who appears for that college? Is there appearance for that college?
IA allowed.
Lord, I have
Yeah, we have served them, my lord, through post.
not seen anybody who's appeared for that college. That is a new college now. Maybe
The question is only this, which year are you in now?
I'm in 3rd year, my lord. I'm supposed to appear for 3rd year examination now, 3rd year classes now. I have passed in 2nd year.
Pass some orders and get this over with.
Lord, we are.
Into the 3rd year and seeking transfers from college to college. All you have to do is say that at whatever rate they paid, let them continue their studies so that that's the end of it.
May I request,
It
my
is
lord,
not
to-
for us to do it. It's for you.
my lord, there is a challenge with regard to the fee structure, my lord. If my lordship should.
Different.
Who has raised?
Lord,
the
that
challenge?
is what the issue is here, my lord, that
Only this. there's no
notified
challenge.
fees.
They're absolutely notified fees. So now that they have continued their education at the rates, all you need to do is say that they'll be allowed to continue at the rates that they've
My lord,
done till now.
my lord, there is one issue, my lord, that the colleges will not agree now. So since the matter is.
Have to agree. They do not have to agree.
Lord,
The-
since the matter is pending, my lord, They are hoping that it will be decided in their favor where the fees will be fixed as notified fees and not what they had paid in the earlier college. That is where the issue is.
We have reached a stage where they are in their third year of
I
study
agree, my lord.
and they have been accepting the fees. And as a matter of fact, these are exit students, exit fees. So can't we just,
May I request my lords to take it up next week, my lord? I'll communicate this with my.
can we do something?
Please,
Can we say that this question of fees
Please.
will be decided by you as an interim measure, and we'll post this so that all this is not required?
The EME has no objection if the colleges are ready.
Yeah, we have no objections even now.
Got this, because then the question does not arise to either to give a finding
I-
or to say anything
Then the
about it.
difficulty is this.
No, there is a serious problem, my lord.
There is no requirement for them to be transferred in the middle of their course. If you
Agree.
say that, if the colleges should accept the fees as they are.
Basically, what my learned friend
They
also.
have not, none of the colleges have as a matter of fact challenged it. It is your stand that it should be the notified fee.
Lord, basically, what my learned friend is also saying is the same thing.
Going by the orders, we may have to agree that it is a notified fee. But then the difficulty is this, they have paid a lesser fee. They have been taken on the records of the, on the rolls of the colleges. And they are continuing their studies. Midway, if they're this kind of, this is absolutely not required.
May I request, my lord, we take it up next week, Thursday or Friday, my lord, I'll communicate the same thing
You
and
don't,
ask them to issue a direction to accept this.
Lord, as per the honorable court, permit the transfer of data and portal details of so-and-so
Okay, paragraph
to their new
says,
institution.
Please note that this transfer is subject to the final outcome of the petition. Again, he's putting an ankush over there. This is, I'm making it very clear, my lord. This entire, no college has come forward before this court to say, give me the fees. It is only the DME, and for reasons which I cannot spell out before this court now. DME is batting for them. Last time, my lord recollects, my learned friend had mentioned on behalf of the DME. And that is why there is a portion in the order of my lord, where it said neither the DME nor the NMC, because we said that it would be easier that way, has anything to say about it. Virtually on those lines, my lord's order is there.
Can we do something? As a matter of fact, as of now, how many students who have been
Everyone.
transferred have been taken on the fee that was collected by the college? How many? Without the court orders, how many have been taken on the fee that was taken by the first college? Almost most of them.
Have gone to other now retransferred.
Mm.
Otherwise, rest of them have accepted the colleges.
And the earlier year? No, the earlier year or the next year? There are two batches. Two batches. All of them except these persons who have now claimed the transfer. Everyone else has been accepted by the respective colleges at the fees.
That they have accepted.
How can this exercise or transfer now be an interim measure? Continuously there is, I need not repeat, my lord. My lord will have got tired of my repetitions on these issues.
Can we do this?
Please,
As a matter of fact, what was the intake for the first year?
Lord, 150,
21, 22, what was the intake?
150, 150.
150. They were all transferred to the.
They were all
other
transferred.
colleges. Except for the persons who have come here claiming that they need a retransfer. Everybody else has been taken on the fees that were paid in the earlier colleges.
Please.
Now, on the basis of the interim orders, they've continued their education till now.
Please.
Can we just not say that that will be taken as the fees?
Lord, I leave.
We understand legally what your contention was otherwise. But now that most of them have been taken, they've written their examinations on those fees, and it's not as if the colleges are losing out on anything.
May I request,
This
my
is
lords?
in excess of the number of seats that were allotted to them.
Yes.
So therefore, it is not as if they are in any, we're just asking you, please make your stand clear. If that is
Lord,
clarified, that is the end of it.
May I
We
request, my
don't
lords,
need
to
know
take it up
this.
tomorrow? I'll have a word with my officials, my lord, and I'll make my submissions tomorrow.
Learned AG appearing for the DME seeks a short account. Cannot be tomorrow or day after. seeks a short accommodation to get specific instructions from the DME. List next Monday. No, not Monday.
Day after. The sooner the better, my lord.
First.
But some inconvenience on 1 and 2, my lord, I might not be available. I'm sorry, my lord. I'm ready for tomorrow, day after, my lord, top of the list. It's only to convey what they have said.
That it not be possible to list it tomorrow or day after.
I mean, I leave it to
For reasons that you are aware of. Yes.
Grateful.
Seven. Rakshita DJ.
Appear for the appellant, my lord. This MFA, we challenge the judgment and the award passed by the LAC proceeding act, enhancing the award from the 18 lakhs to 2 crores.
187 days delay.
Seven.
Which is this item? This is item 7.
7.
Notice has to go.
My lord, they have issued filed the execution proceeding. Execution proceeding, they have attachment for warrant has been issued. I think the
Why you looking for delay then?
delay there, my lord. My lord, due to the legal opinion and the approval from the authority, the delay has been with bona fide, my lord. They wish.
Pending consideration of IA 1 of 2025, IA the operation and execution of the impugned award. Impugned award is stayed.
On condition.
Still in a state of affairs.
On condition. On condition.
On the condition. Yes, yes. The condition that the appellate shall deposit entire
My lord, 25% of
50% of
50%.
50% the award amount within 2 weeks.
Yes, my
Within
lord.
2 weeks. Also, on such deposit, the respondents are at liberty to withdraw the same by executing the indemnity bond.
Execution proceedings, my lord.
Yes.
Depot.
State the execution proceeding. Award and so award is stayed.
Yes.
Before this code, 50% before this code.
Yes.
This code, execution code.
Execution vote is easier.
Before
Let them-
execution, code.
let
Before
them-
execution, code.
Execution.
Issue notice to respond number 1. 11 AG is directed to accept notice to respond number 2.
B group, still number 8.
My lord, kindly pass on. Pass on. 8 and 9. Both.
Orders, number 10. RS Hegde.
Non-filing of non-compliance. Notice objection.
Appellant in one of appeal number last.
2 weeks time granted. 2 weeks time granted to comply the office objections.
11. Sachin BS.
Plans of office objection. Paper book also.
In this matter, my lords, I have given NOC, my lords, some other counsel has already entered appearance. Kindly delete the name of Sachin BS, my lords.
Who is the other counsel? Idya, Bandida, Makalatu, Putapagi.
Yes, Vema Reddy.
Vema Reddy, yeah?
Appellant number 1 is not being prosecuted. Because
My
it
lord,
stands
I have-
abated.
Separated.
I have issued NOC to all the appellants, my lords.
Since appellate number, what about 2, madam? 2 here is there? 2 and 3 Vema Reddy, yeah, noting?
Illa. A3 matra.
A3 matter.
A3, A to C.
Then counsel for the appellant, Shri Sachin BS submits that he had filed NOC to the appellants. Hence, issue notice to, full stop. Office notings reveals that appellant number one is no more and appeal stands abated against him. Hence, issue notice to appellate number 2. Shri Vemar, Learned Counsel Shri Vemar Reddy filed a power on appellate number 3. Its office is directed, already shown, is it? Yes, that's better.
My name may be deleted. ma'am.
Yes, office directed to delete the name of Sachin BS.
12,
And for the appellants in this case, ma'am, paper books are ready, ma'am. Kindly grant 2 days, ma'am. Within 2 days we have filed.
Weeks time granted to file the paper.
What's up?
Sometimes
2 weeks.
not so.
13, DM Sidappa,
Paper book, 2 weeks time may be granted.
In this, because the first respondent is aged about 78 years, my lord. The relationship is questioned. One partition suit filed by this first respondent has been decreed, holding that she is the wife. My lord, the husband of the first respondent was a legislator, my lord. He had declared that she is the wife. They have unnecessarily been dragging.
No, my lords.
One
It is the last chance, my lord. One.
declaration also has been dismissed. Against that appeal was filed. That was also dismissed. So second appeal is pertaining to that only, man.
Due to some financial crisis, they are
Some
not able to pay the paper book fee, my lord. That's
Has
why.
no-
Learned Counsel for the respondent submits that the respondent is, late evening of her life. So I insist for taking the
But the other,
matter for hearing. However, there is office objection. Finally, 2 weeks time granted to comply the office objection.
But finally,
Finally.
if it is
Yes,
my lord, not complied with within the time, it will
Okay,
should stand dismissed. That's it.
paper book also. Paper book.
Paper book, the paper final book.
14, PM Sidmalappa,
Respondents 3 and 4 are compromised. This honorable court directed in 2019 to file paper books within 12 weeks. That is not done. Specific performance suit. 2 parties have agreed for compromise and they have filed the petition. I am in difficulty now. I have moved the matter, my lord. There in the land, there is a issue now. So therefore, there is urgency, my lord. 12 weeks was granted to file paper books in 2019.
Finally,
Appearance for the appellant.
finally, a week's time granted to file paper book.
Say no appearance for the appellant.
Any date, my lord.
Finally.
Otherwise, they will not file it, my lords.
Yes.
2015 matter. Great.
15, Ramchandra Ji Bhatt,
Hearing for the appellant, my lord. So this is the appeal filed by the defendant, my lord. Now, this application is second application. First time, Lord, I am not pressing this application in view of the application existing already filed along with the appeal.
Yes.
It is some urgency, my lord. May I make my submissions, my lord, in this case?
Early suit.
File number 1 of 24 is dismissed, has not pressed,
Please,
This appeal for admission.
admissions. May I make submission with my urgency in this matter, ma'am? May I make submission regarding admission, my lord? Please.
Admission ಬರ್ಲಿ.
appeal memorandum ಕೊಟ್ಟಿಲ್ಲ. 2016.
ನೋಟಿಸ್ ಸರ್ವಿಸ್ ಆಗಿದೆ ಅವರಿಗೆ ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ.
Next week ಅಲ್ಲಿ ಹಾಕು.
ಅಲ್ಲ ಯಾಕೆ ಅಂತ ಹೇಳಿ ಸ್ವಾಮಿ ಮೇ ಮೇಕ್ ಮೈ ಸಬ್ಮಿಷನ್ ಮೆಲಾಡ್. Dispute is between the present appellant and the association of the apartment owners association. Lord, there was the basic facilities were disconnected, alleging that I have not made the payment of the maintenance charges. Lord, there was a dispute, but according to me, 10,000 was in excess.
New first appeal has to be admitted. ಮತ್ತೆ ಅಲ್ವಾ hearing
ಅಲ್ಲ ಅಂದ್ರೆ ಅರ್ಜೆನ್ಸಿ ಏನಂದ್ರೆ I have filed an application, my lord, directing them to connect the basic facilities, my lord. I have deposited 6 lakhs rupees. Lord, I have completed the decree, my lord, deposited the amount also.
List the matter for admission next week I'll update.
Lord, in the meantime, the difficulty, my lord, is I don't have water facilities, though I am a owner, my lord.
2-4,
Possible to hear on that.
Pardon me.
We will hear on that.
2-4.
16 mat. Next week, lordship, can you give it?
Next
date
week.
for that?
2-4. Of that. Yes.
Meanwhile, let him serve me a copy, my lords. Otherwise,
I will send,
That we will not order. Copy ಇದಕ್ಕೆ ನಾವು order ಮಾಡ್ಕೊಂಡು ಕೂರ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
I will serve my copy.
great.
Appearing for respondent number 4, your lordship. Serial
I
number
have
16.
taken out the paper publication, my lords, on 22/2/2025, my lords. I have taken.
And counsel for filed a memo along with the paper.
With respect
Paper
to my lords,
publication.
2A, B, C, my lords.
Respondent to.
2C, my lord. 2C, my lords.
2C.
Yes, my
Called
lords.
out. Absent in the format. Called out, absent and sufficient. Service and sufficient. Yes, office to,
Preeti, yes?
and sufficient, office to print the name of R2C. Necessary amendment. In the cost of,
Yes, my lords.
shall be carried out. Yes,
In 1 week, I will carry out the.
yes. Time granted.
Seventeen,
My lords, in this matter, my lords, I have paid the process fees and everything I have done, my lords. And I have obtained the records also. I will file it in the counter by end of the day.
For the appellate subjects need. That we so office to verify and put up.
17.1.
Copies have been served.
Copies, my lords, I have.
But last few occasions, they've taken time to show whether our portion was depicted in BTM 6 stage for utilization.
My lords, I have, insofar as my lords, 2 writ appeals, my lords, there was, notice was not ordered. We have paid the process fees and necessary steps has been taken. My lords, we have obtained the records also. We'll file it in the counter, my lords, by end of day tomorrow, my lords. It may be posted next week, any date. Much.
Give a date.
15/4. Eighteen, Harsha Kumar LS.
Your lordship, one submission, your lordship, in
Appears-
this matter, learned advocate general is appearing, he's having some inconvenience, Your lordship may fix up some other date.
What about this objection? So
What about the office objections? There appear to be several office objections.
Now, basically, last time we had suggested we want to argue on the main matter itself.
Adjourn with an understanding to argue finally antla.
Finally,
Any date, your lordship, 17th.
What is this about?
with regard to the fixation of a value of a property which have been granted by the government as per the by the cabinet.
The request of AGA. AGA
17, you,
79.
17.
17.
Yes, please.
Notify on 17.
Public marriage.
Nineteen, government advocate.
My colleague is appearing, kindly pass over, your lordship. He is ready.
Awesome.
Twenty,
Paper publication. Paper publication.
The fourth respondent has been served through the paper publications.
Town council for the appellant files a memo along with the paper publication.
In both the matters.
Both the matters, appearances there now.
Yes.
Paper publication.
Srimati S. Rajeshwari.
Effect of respond number 4.
She has been represented by Learned Counsel.
VHK.
Yes.
Ravi HK.
R4, madam.
Yes.
R4 called, remained absent.
No. It appears what is
Not these.
Publication.
after that, it appears that one is in time.
Oh, memo.
What can be? Yes, so that, no.
The applications are filed by the appellant.
Your
Number 4, my lord.
Wakalat file?
Wakalat has been filed, copy has been not served. We have to file objection.
Now,
They served copy.
they were-
next day we file.
they were respondents in the original proceedings. The contesting respondent in the present case is the first respondent. Copies will be served. There's no difficulty about that.
But the contesting respondent has not filed objections to INS number 1 to 4 for the last 6 months. And actually, he has to have his say. And we have served all the papers. So far as this respondent is concerned, there is no difficulty.
My lords, is short
R1.
R1, my lord.
The respond number 4. They short.
Because without
accommodation,
making us
file
parties.
Objections, if any. Objections for IA number 1 to 4,
1 to 4.
1 to 4.
For last 6 months, they have not filed.
Finally on the.
ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ ನಮ್ಮನ್ನು without making us parties, will not have obtained an order.
R4
Actually,
has just now been served.
R4 is no difficulty.
Copy ಕೊಟ್ಬಿಡಿ R4.
Very well.
ಆಯ್ತು. Final 2 weeks time granted.
Yes, great.
1 days.
Both this and the connected matter,
File objection file what?
in both the matters.
Yes, yes.
Grateful, man.
ಕೊಟ್ಬಿಡಿ.
21-4. 21, Pawan Chandra Shetty.
Counsel suppression, without the office objection.
Land user appeal, my lord. Wherein, my lord, there are many land has been acquired by the authorities. I have made a party, my lord, as my lord additional, who is the beneficiary authorities, the executive engineer, PW department. However, my lord,
The
both are
objection is
state,
only that an IA has to be filed.
but both are state, my lord.
That is not the question.
But what happened?
R2 is not there before the
Yes.
trial court. When you're filing appeal, you add R2.
Yes.
IA has to be filed. That
Please.
is all.
What happened? May I make one submission? In other connected matter, my lord, what happened? While filing the contempt court has raised the objection. Why beneficiaries has made as a party? So that in rest of the,
Question counsel, we understand that you want to make the beneficiary a party.
yes, ma'am.
You did not make the beneficiary a party before the trial court.
Please, ma'am.
Therefore, when you're filing an appeal with the beneficiary as a party, an IA has to be filed
Please,
to implead.
I
It
will
has to be
file.
there.
Yes. Ma'am. In the meantime, notice may be ordered to state, my lord. I will serve the copy, my lord.
Please make the beneficiary also a
Please,
party.
please.
File that IA, it can be ordered on both.
Yes, please. Oblige. Next week.
Each time granted to the counsel for the, at the request of the counsel for the appellant. Each time granted. To
Number
necessary
22.
applications of that.
Jairaj DS, notices to.
Appear for the
15 days.
appellant. Last time we had complied with the office objections
Succession.
and the
Succession.
last time we had, please, my lords. Okay,
Issue
the lordships,
Notice agreement, issue notice.
Illa, no parties,
No party.
no parties.
Ah.
The lordship's permission, may I, my lord, submit on merits.
Registered will dated
Please.
21/2020.
Please, lords, this property, two properties. One is the ancestral property, another one is a self, please.
Succession.
The Honorable Trial Court has dismissed my petition only on two grounds. One is that the requirement as per section 2F by virtue of me being a Hindu may not be necessary. Secondly, more importantly, the Honorable Trial Court comes to an erroneous conclusion that when an will is executed, executor has to be named in the will, which is also, my lords, covered by this Honorable Court's judgment.
Question is only whether you
Please.
should have made the second wife and children party to the proceedings.
Prior to that, my lords, very importantly, my lords, a release deed was executed
Hmm.
in favor of the second wife and the remaining children.
Hmm.
And they have got their respective shares.
Whether they have got their shares or not.
Yes,
Whether they are necessary parties to this application for probate is the question. Correct?
please, my lords. 23rd of May 2018,
Yes, well, tell us whether they are necessary parties.
#276 may kindly be looked. Petition for probate.
Hmm.
application for probate or for letters of administration with the will annexed shall be made by a petition distinctly written in English or in the language in ordinary use in proceedings before the court, in which the application is made with the will or in the cases mentioned in sections 237, 238 and 239. A copy, draft or statement of contents thereof annexed and stating the time of the testator's death. B, that the writing annexed in the last will and testament, that it was duly executed, the amount of assets which are likely to come to the petitioner's hands when the application is for probate, that the petitioner is the executor named in the will. In addition to these particulars, the petition shall further state when the application is to the district judge that the deceased at the time of his death at a fixed place of abode or at some property situated within the jurisdiction of the judge. When the application is to a district delegate, that the deceased at the time of his death at a fixed place of abode within the jurisdiction of such delegate. Where the application is to the district judge and any portion of the assets likely to come to the petitioner's hands is situated in another state, the petition shall further state the amount of such assets in each state and the district judges within the whose jurisdiction such assets are situated. Now, my lords, I have complied insofar as this section.
Public notice was taken. of
Yes,
the
my
petition.
lords, it has been accepted. Only on these two grounds. Even the very statute, that is section 222 of subclause 2 and 234. May I, your lordship's permission, may I take your lordships to the impugned judgment?
Just a moment.
Please.
In every case where there is no contention, but it appears where there is contention. It's against grant. Yes.
My lords, paragraph number 12, running page number 32 may kindly be looked into. The reason starts from there. Internal page number 11. Para 12.
Just a moment. Please. He died on 8/3/2020.
He died on 8/3/20. Right, ma'am, that's right. Will is of the year 20th January 2020.
This is J1, 11/3/2020. You have it here. This is examined with this. The testing witnesses were examined.
Yes, my lords, PW2 and PW3.
Certificate. Will be the RTC release date, date of application. Have that. Executor. We have not had arguments on the other side. See the provisions. 281 says, 281 is verification, never mind that. But probate and letters of administration may upon application to that purpose. Take your uncle wherever it is. Is it this? Unless it is not required. Who is? We do the executor. But here. Probate only for conflicts. Probate shall be granted only to an executor according to the law. Appointment may be expressed or by necessary implication.
Evidence.
The illustrations will speak about sole legatee. We've held that, so that no case is there in, these are all in uncontested cases that we are holding. Yes.
Please, Lords, now the only point for consideration before your lordships is whether even the executor claiming as a beneficiary can be entitled under the will.
That would it not depend on the, on what the will says with regard to the.
Definitely, my lords,
Hmm.
definitely. I have produced the will.
Hmm.
And my lords, I have
Is
proved the
in-
will.
Is the will in English?
Yes, my lords, I have got the translated copy also by
When is
filing it. It was filed on 19th February 2025.
February. There.
Page 10. Page 10, your lordship.
They had rights which they have relinquished in favor of the testator.
Yes, my lords. 2 release deeds, registered release deeds. Because apart from this property, I had obtained several other properties. Therefore, the exhibit P4 and P5 was executed.
What do you say about the contention that no will is required?
Please, my lords.
What do you, I mean, no probate is required. What do you say about the
My lords,
contention? that
probate
no
is
will
required, my lords. Probate is required. Because, my lords, my only ground seeking probate is, my lords, I sought transfer of kata and all the revenue entries, which was objected by the concerned jurisdictional Tahsildar Therefore, I approached the Honorable Trial Court seeking the probate, which was dismissed on these only two grounds, that I am not the executor named under the will. Therefore, me
Weight
claiming
of
as
will, when granted, establishes the will from the death of the testator
Yes,
and renders valid all intermediate acts of the executor as such.
if I may draw your lordship's attention to the impugned judgment, on what ground it was dismissed, my lords, para 12 may kindly be looked into.
Yes.
Now, the question of consideration before the court is whether the petitioner is entitled to seek probate and letter of administration in respect of will dated 20th January 2020. It is to be noted here that the petition did not disclose the cause of action to seek the relief of probate and letter of administration, even though the date of cause of action is mentioned as 20th January 2020 and 8 March 2020, but mere death of the executant does not bring any cause to file this petition. On perusal of the entire file, it is seen that petitioner and deceased B.T. Sanjeevaya are Hindu by religion. It is needless to say that the will executed by Hindu by religion need not require any probate to enforce the same. Anyhow, before considering whether the petitioner is entitled to seek probate and letter of administration, it is just and necessary to refer section 222 of Indian Succession Act 1925, which speaks regarding to whom probate certificate is to be issued. The section 222 of Indian Succession Act 1925 defines to whom probate certificate be issued. It says, probate only to appointed executor. Probate shall be granted only to an executor appointed by the will. The appointment may be expressed or by necessary implication. This is the first ground for the reasoning. Para 14. Therefore, the above referred section is very clear that the probate certificate has to be issued in the name of the executor appointed by the will to maintain and manage the properties of the testator in accordance with his or will and wish, but the executor cannot be the beneficiary under the will. At this stage, it is relevant to refer the definition of the term executor defined in section 2C of the said act, as executor means a person to whom the execution of the last will of a deceased person is by the testator's appointment confined. So on careful reading of the above provisions of law, it is very much clear that in order to issue probate certificate, the minimum requirement under section 2 IE of the act is that the person who is seeking probate certificate has to be named in the will as executor by the testator. The said appointment may be expressed or by necessary implication. 17. In order to know whether the petitioner has been appointed as executor either expressly or by necessary implication in the will by the testator, it is just and necessary to verify the will. On perusal of Exhibit P1, it is seen that this petitioner is not appointed as executor of the will by the testator to manage or maintain the properties mentioned in the will. However, as per the recitals in the said will, the petitioner is the beneficiary, but not executor appointed by the testator. Accordingly, it is very much clear that this petitioner is not appointed as executor in the will either expressly or by necessary implication by the testator, only to manage and maintain the properties listed in the will to issue probate certificate in his favor. No doubt, in the petition, it is stated that the petitioner is the person in whose favor the will was executed, but only based upon the said averment, probate cannot be issued. In fact, the petition, it is clearly stated that the testator bequeathed his properties and assets to the petitioner. Therefore, the petitioner cannot be the executor appointed by the testator. Instead, he is the beneficiary of the will. Thus, the legal requirements as required under the law to issue probate certificate are not fulfilled by the petitioner. As stated above, the will executed by Hindu does not require to obtain probate. Accordingly, the petitioner is not entitled for probate certificate pertaining to will dated 20th January 2020 as sought for in the petition. And accordingly, it was dismissed. Now, let's kindly see.
Yes, have you seen the
Yes,
legal
my lords.
judgment?
Yes, my lords, I have. Lords, even the beneficiary under the will can maintain.
Both these questions have been decided? Both the questions have been decided?
It says co-joint reading of 222 subclause 2 and section 234 of the Act. Lords, in this, the similar set of circumstances where, yes, my lords.
You've not seen the further judgment on the very same point? There is a division bench judgment on the same point. I've not seen this.
Yes, my lords. Para 12, my lords. It states about the facts.
None. ILR. No. Me and Vijay Kumar Patel, it's reported in ILR.
Para 12 states the facts of the said case. Having heard the learned counsel for the appellants and on perusal of the material on record, it is the case of the appellants before the trial court that property was granted in favor of one Sanga Rangappa wide so and so, dated 22nd November 1978. It is also their case that grantee was in occupation and enjoying the same by cultivating the land. It is also their pleading that the said Sanga Rangappa was unmarried and during the lifetime of said Sanga Rangappa, the father of the petitioners and the petitioners were looking after him with love and affection. It is also contended that said Sanga Rangappa executed will dated 14 February 2001, which was registered on 15 February 2001, and the said Sanga Rangappa died on 29 June 2001. It is also pleaded that based on the said will, an attempt was made to transfer the kata and the same was rejected by revenue authorities. Hence, they approached the court seeking the relief of probate. The trial court no doubt take note of issue of notice in 2 daily newspapers and none claimed any interest in respect of the property, which is the subject matter of the will. However, proceeded to pass an order of rejection referring to proviso of section 222 of the Act and also considered the judgments of the Delhi High Court and the Apex Court. Having perused the judgment of the Apex Court, the principles laid down in the said judgment is with regard to the probate proceedings, and if a probate proceedings is initiated, the transferee would be deemed to have notice thereof, and the same is not on the issue involved between the parties with regard to the appointment of the executor. No doubt the Delhi High Court comes to the conclusion that probate cannot be granted to any person until and unless his name is executor in the will. This judgment is of the year 1977. And the very same issue is considered in MFA number 3238 of 2019 dated 7th November 2019 by this court, and the point of consideration framed by this court having considered the factual aspects of the case directly touch upon the issue involved in the case on hand. The point for consideration framed by this court is whether the beneficiary could file a petition under section 276 of the Act when there is no executor appointed and whether the court can grant probate of a will on a petition filed by a beneficiary. Having considered the point for consideration and also the very proviso of sections 222 subclause 2, 231 and 243 of the Act in detail discussed with regard to factual aspect of the said case and comes to the conclusion that no doubt section 234 of the Act states that when there is no executor.
You understand?
Please.
2 things.
Yes, madam.
One is that in both these cases, we've also decided there's a division bench judgment
Yes,
by a different combination, which says the same thing. We've decided that if a beneficiary,
Yes,
a sole legatee in a will,
sole legatee.
sole legatee in a will is also an executor by implication.
By implication, please.
It's only that the illustration does not speak about such a situation.
Right.
But even so,
Yes,
because otherwise, in all wills where there is a
No
sole legatee,
executor.
no executor,
Yes.
then it cannot, no probate could have been granted.
Yes,
We've also decided the question that though probate is not required for a Hindu,
yes,
there is nothing wrong in seeking a probate and getting it.
absolutely.
So, but in both those cases, notice had been taken out at the appellate stage also.
Here there are no respondents.
Same was the case there also. Here, this case also the
I have
judgment-
no impediment insofar as that is.
That's it.
But-
That may have to be taken. Normally, we understand it may not be required, but in a case where they are not made parties as such,
Yes, my lords.
and you say that they have no objection. If they had been parties and they had not come, then that would have been the end of the matter. But otherwise, in the appeal, for the appeal to be allowed, should we not order notice is the only question. Because it appears in all these cases, the cases which came up for us,
If that is
where
so,
it has
then
been
I will.
decided also, notice has been ordered, notice had been taken up.
Yes, if that is so, I will take it, my lords. Only, if I
Learned
would, I would
counsel
only
hearing
request a
For the
specific
appellant
dates.
submits that the question raised in this appeal stands covered in favor of the appellant by a judgment of this court of a learned single judge of this court in M.R. Mohan Kumar and others. Versus nil 2024-3 Karnataka LR 414. We notice that there is also a division bench judgment of this court on the point in the above view of the matter. The issue notice to the respondents by paper publication.
Please.
IA has to be, no, IA does not have to be. Issue notice by paper publication in what newspaper?
I have taken in Vijayavani. Madam.
Vijayawada. Yes, please give the dates also.
Specific dates only.
The property is in Nelmangla,
Yes, my lords.
Bangalore edition.
In the trial court also, I took it in Vijayavani.
Vijayawani, Bangalore edition.
Yes, yes, my lords. Rural, it comes to rural.
8th April,
8th April,
28th
April.
April, hearing.
Please. I will. Grateful.
Before 15th.
Then delay also will have to be controlled.
Honor before 15th, you take out the paper.
If somebody comes and asks, business because in one case, where there is a manifest dismissal, this issue will be taken. Whether in one case where the respondent, some party comes in, files the waiter's agreement, says that he's not the waiter, therefore he can undo, and then both sides will agree. Here, we are just looking at the provisions and saying that in all these cases where there is no dispute. That is the concept. Otherwise, what we could do is we could add these whether there are any decisions against.
Passed over matters. Preliminary hearing, seal number 4. Juristia.
Senior counsel wants to argue the matter.
We Kharab land.
12 meters of Kharab land in survey number 12/7 of Chickbilander village. Mr. Vikram Wilgol wants to argue the matter. Short pass over minute.
Paso.
8. Seal number 8. Madevi Ramat.
Just a minute, please. Just give us a moment. Yes, this is 3238.
Abhishek Mani Patel. Abhishek Mani Patel, avunu.
That's right or not, there will be nobody to take this up. It is the difficulty. Is why I was saying, filed in paragraph. Yes, we will. To tell us whether there is any impediment, whether there are any decisions to be, yes.
The expression, this one is not enough, and that is the.
Correct.
Still,
Still, that's what I thought.
this is beautiful, that is, this is right.
Earlier case, sorry. Just keep it in the file. Keep that judgment in the file. Yes, sorry. No, 6-8 is with regard to,
That is with regard to 5976.
no time limit provided for surrendering.
My lords, serial number, next serial number has bearing on this, my lords, because my lords, that is the issue which is involved. Your lordship directed that surrender the seat center, notify those seat centers. That is the only prayer which survives in this serial number 8.
So 9 you want
Nine,
us to
there
call.
has to be
9 my lord, the
decided.
pleadings are complete. 8 is subsequent.
9 notes is the question.
Where is R4? Please show the item number 9, otherwise he will not know. He had sought time to file some objections today, not filed. R4. Abhishek had,
They have received the additional statement by the day.
and they wanted,
Therefore, they wanted time to go through.
show the item number as 9. Shown. 9 is shown.
Display. 9 display ಮಾಡಿ ಅಭಿಷೇಕ್ ಬರ್ತಾರೆ ಮಾಡಿದ್ದು.
6060. Yes. Please, item number 9.
Serial number 9, Milos,
9.
seek for a short password, Milos, he is on his legs.
Can we come at 2:30, my lordship, please?
Please.
Can be a 2. But only 19.
Government advocate. ಕರ್ಕೊಂಡ್ ಬರ್ತೀನಿ ಅಂತ ಹೋದ್ರಲ್ಲ. ಬರಲ್ವಾ?
Final hearing, we can't take up RFA matters either. Are you ready in any final hearing matter?
Won't be speechless. 19 ಏನ್ ಮಾಡಿದೆ? So.
Okay, that is that service matter. Just a minute. You can come, CNR rules, nursing staff, medical colleges.
Short pause my lord.
Please tell the arguing counsel that we are waiting for him.
Mr. Vikas Roji will appear, my lord. Vikas Roji, yes, my lord. He's in quarter number 7, he will appear it.
Please tell him that we are waiting for him.
Immediately. 2 minutes.
Who appears on the other side? Respondents?
Vijay Raghava Sarathi. Vijay Kumar.
He was ready.
He was
It was also probably held up somewhere else. Because only 11:45 admissions are probably going on in other courts. Medical colleges means that other colleges have been established. Colleges have been made as autonomous institutes for another institute control of medical education. It's a utilization of medical hospital in district hospital. Of the concerned district has been attached to autonomous medical colleges. So certain of the staff of the colleges have been made as It's also the
You are for respondent.
I'm sorry to explain.
Serial number 19.
Serial number 27.
This is serial number 19.
25. You are at serial number 25.
Let us see, let us see.
Injunction,
It is
RFA.
25 RFA and 27 is also RFA.
They are at 25.
25. Injunction suit. We thought you were saying everybody is ready in the matter. No.
They constantly appearing.
Can, if that could have been taken. 25 is an injunction. First appeal from an injunction suit. 25 is not partition. It's injunction.
The adoptive son files a suit for partition.
Adoptive son.
Property acquired by his adoptive mother during his tenure as a scientist in National Aeronautical Laboratory. That was her self-earning property. He asked for a share in her self-acquired property. And that was granted. It's a very short question. I believe that anytime they get ready, it's a matter of.
They started to engage senior counsel also. Next week.
There was any possibility of settlement? This son and.
Absolutely, I mean, parties are not to buy peace to make war. They are not at peace. And hardly he met with the adoptive mother for a few days and he walked out and got married himself. And in fact, I advised the parties to hold olive branch and seek for peace. They did not. They are at loggerheads.
There are no other children? Only this one son, this adoptive son, no other children?
No, later she got married. She adopted the respondent when she was a spinster. There she committed a tragedy of error. Later she got married and got a daughter.
Is the problem?
Can it be shortlisted next week so that
Shortlisting and all.
candidate continuing to report?
16-4.
Yes, at the
16-4.
request of the learned counsel for the respondent. Yes.
24 hours. 29.
It's covered by this
Yes.
court and also Supreme.
Yes, yes.
Here in this case, my lord, we had filed the challenging the
19.
My lord, LAC, my lord, awarded 105.
No.
My lord, this court, my lord, confirmed the order passed by the LAC. Thereafter, my lord, appeal SLP filed by the executive engineer, my lord, same also dismissed confirming the order of LAC as well as the judgment of this honorable court, my lord.
Upper Tunga project.
Upper Tunga project. Your lordship has disposed one matter, my lord.
Yes.
This may not become.
Tunga. It can be.
Yes, yeah.
Please, ma'am.
Dismiss. Dismiss, yes.
Reasons to follow.
Reasons to follow, dismiss.
Serial number 30.
Government to secure records.
That's good.
There was a land acquisition matter, may not.
Minor represented by mother.
My love, one submission made, KIDB is a beneficiary. SLO, KIDB, government is not a party. SLO, KIDB is
R3. R3.
KIDB.
SLAO, KDB.
SLO, KIDB. It's a separate panel advocate, Chandrasekhar is a.
Gazette order.
R2 is KDB.
No, R2 is a
R3.
personal,
Who's R2?
private party.
The private party may not sue claims against me, the contesting respondent.
R3 is special land acquisition officer.
R3. So
KIDB
it has
is
KDB.
Chandrasekhar name may be shown.
R1 to R. Is all this. R2 is private party. R2 is already represented. Then-
Party.
Okay, so R2 has to be represented by the KIDB. R3. R3 is the HCG. Okay, that's the SLA. Yes.
R3 is represented with conflict and
So and so learned councils, learned government advocate submits that the third respondent is the special land acquisition officer of the KIDB, and that there is a panel advocate appearing for the KIDB. Show the name of the,
No, the name may be shown, Chandrasekhar,
show the name of so and so.
and may not
learned
list
counsel
it on
for
a day,
KIDB.
any day. I'll show him personally.
List on the learned counsel for the petitioner undertakes to serve counsel. Serve copies of the
7-4.
appeal and all papers.
7.
The learned counsel appearing for our.
7-4,
7-4.
Monday.
Apply.
Yes.
Lord, serial number 19 by 230, my lord. Is stuck up in quarter number 7. Maybe,
No 2:30. We'll have it on some other day.
please, my lord.
It on some other day. Called learned counsel, learned AGA is not available to argue the case. List on
Last week. Anyway,
28-4.
8, please. ಬರ್ತಾರೆ ಸಾರಥಿ
BDA. What, which is the acquisition?
Number 6449 of 2017.
2017. 33. 33. Just a moment. 27/4/2015 preliminary notification. (29/12/2015) final notification. Center.
What happened is that my lord, a batch of petition was filed regarding challenging the Authorized. That what has happened is that my lord, a committee was formed and all matter was referred before committee members. This matter is concerned, the opposition pertaining to this subject, survey number is has been passed by the, in the petition. Challenging that we are before the lordship. It has to be referred before the committee members.
Just a moment, please. Three 25 square meters of land.
My lord, I appeared for.
33.
To be tagged along with other related matters.
With regard to the very same survey number, very same acquisition. Here, the question is only this, whether there is B Kharab land within the property which is acquired. That is all. Where is the direction with regard to reference to the committee? Arkavati layout. That is all, to agitate the same in accordance with law, seek payment of compensation accordingly. Finding is that there is no B Kharab land. Whether there is B Kharab land or not also can be examined by the committee. What is the issue that has to be considered by the committee?
Regarding the challenging of acquisition, my lord, everything has to be referred before the committee.
Where is that judgment which forms the committee? What are the matters which the committee has to decide? Whether the question whether there is B Kharab land or not is a question which has to be decided by the committee. If it has, it can go, because all that is stated is that liberty is reserved to agitate the same in accordance with law, seek payment of compensation. That is all. Therefore, if the question with regard to identity also has to be agitated. You say there was a road. They say there is a road, Pakka road, not the path that you're saying existed. There is a Pakka road. It is without considering that Pakka road that the acquisition has occurred and 123.67 square meters has been acquired. Is their case. It is only a question of physical verification. Now your second, there are two sketches. One sketch shows a path along that property. The second sketch shows that there is no path within the property. Your sketches. So therefore, the learned single judge comes to the conclusion that the property has been acquired, compensation has to be paid. This is all there is to it. Yes, please tell us what exactly is the mandate of the committee, mandate to the committee. Bring it in the afternoon. When you're called upon to argue a case, should you not at least have the basic, you say that it is covered by a judgment. Should you not have that judgment with you?
Listed along with that, recap my lord.
It's today listed for final hearing.
My lord, this matter was listed along with that, recap my lord.
Wherever it was listed.
Filed the citation, my lord.
Today, it is, therefore, all you have to do is get that citation from that file and bring it here.
My lord, it was delinked in last year, 224, and there was a direction to him to file a synopsis. Till this day, he has not filed. Kindly refer to page 19. That is the last page of the impugned order. Page 9 of the appeal memo. See, the application is filed for the certified copy on 7/2/2021. When was the order? 20th April 1918. And they seek a condonation of 1,065 days delay. The copy itself is filed after 3 years. And also they have concealed the fact that there is a factory. When there is a factory, they cannot acquire that. That is one of the conditions imposed by the Honorable Apex Court. They have concealed that fact. They say, yes, there are 4 buildings. One building is a factory.
Please place the judgment on record and tell us what the mandate of the committee is. Yes. At the request of the learned counsel appearing for the appellant. This case after a week,
7/4.
not along with anything, just this case. Yes. First convince us that it requires to be listed along with anything else. Yes, senior counsel.
Four.
Challenge is to the judgment of the learned single judge dated 18th November.
Yes.
Before I take my lords through the facts of the case, could I request my lords to kindly see the prayers that we had raised in the writ petition?
Yes.
And I'll come to why I'm drawing your lordship's attention to that. Page 44, my lord, of the writ appeal.
Yes.
The first part of the prayer, my lords will note, is to quash a certain order and consequentially issue a writ of mandamus directing the respondents to consider the claim of the petitioner. My lords may kindly mark this. We are not asking for any positive direction that any land be conveyed to us or be granted to us. It's to consider our representation. I'll explain why I brought your lordship's attention to this. Now, just some background facts, my lords, may not be entirely, I won't take my lords through all the relevant, all the dates. We are owners undisputedly of a land measuring about 1 acre, 4 guntas, which was subsequently converted. Again, may not be entirely relevant, just to complete the sequence of events. If my lords were to see page 65, this is where the
issue really begins. Page number 65 is the translation of Annexure C. It's a letter dated 25th of November 2014, where we write to the Deputy Commissioner to consider granting us a neighboring extent of about 12 guntas of B Kharab land. My lords, has it, page 65?
Yes.
I'll just read it out, my lords. With reference to the above cited subject, the land bearing survey number 12/7, measuring 2.29 guntas in total, after deducting Kharab so-and-so to an extent of 0.12 guntas, that is 12 guntas, the remaining extent is 2.17 guntas, situated at so-and-so village. The Deputy Commissioner has already passed a land conversion order to an extent of 1 acre 4 guntas from agriculture to non-agriculture residential purpose, vide is order dated 23/11/2013. The land which is in my occupation there is 12 guntas of Port Kharab, as stated above. It has lost its character. Also, the said Kharab port ended in the land in question, survey number 12/7, and the same has not been extended. Therefore, it is not required either to the general public or to the adjoining lands. Hence, the Kharab existing in the said land by giving publication in the interest of general public by imposing government fees. So, loosely translated, my lords, what we're asking the Deputy Commissioner is that to please consider granting us this land, since it's not lost its nature. It is abutting our land. We have been in occupation. Please consider granting.
Please tell us what is this nature that it is Port Kharab?
Yes, my lords.
What does that mean?
Kharab land, my lords, is...
And I'm aware.
Yes, my lords.
What is Port Kharab?
Port Kharab, my lords, is essentially the same thing. It is not anything different, but it is government land. Although there is, my lords, one judgment of a learned single judge, actually, my lords, which holds that Port Kharab land is not government land. And interestingly, my lords, that the appeal against that learned single judge's order has abated. So the status of that, of course, I won't go into all that, but just to bring to your lordship's attention. So, but there is a doubt, there is a cloud hanging over the nature of Port Kharab land. What the learned single judge in that order held is that if the land is designated as Kharab land or Port Kharab land, it is only for the purpose of levying a lesser amount of land revenue, to assess the land revenue to a lesser extent. However, it does not change the ownership. Now, if I claim that I'm owner of X amount of Port Kharab land, the issue in that case was whether the government should compensate me for acquiring that land. The learned single judge said yes, because merely because it is designated as Port Kharab land, it is under, so I think, Rule 21 of the land revenue rules. There, it is only for the purpose of levying a lesser amount of revenue, and that does not change the ownership. Here, my lords, I'm not claiming ownership. I very frankly, my lords, I know that it is government land. I have requested the Deputy Commissioner to consider granting the 12 guntas because it is not being used for any purpose. It is abutting my land. I own about 1 acre, 4 guntas. So to kindly consider granting me the land. So that was my first request. My lords will kindly see it was referred to the Tahsildar, Annexure D at page 71.
Yes.
My lords, may kindly see page 71.
Yes.
It refers to our representation, and may I read from the bottom of page 71, my lords, the land bearing survey number 12/7, measuring 2.29 guntas, after deducting Kharab to an extent of 0.12 guntas, the remaining extent 2.17, situated at so-and-so village, has already passed land conversion order to an extent of 1.04 from agriculture, non-agriculture. In the middle portion of this land, Kharab area, which is passing in the said area as per the sketch, also as per survey measures 12 guntas, which is B Kharab, the area of which is sought for grant by the applicant. In this regard, spot inspection was conducted and the said Kharab lost its character, unfit for cultivation. It is passing through the land which has got converted for residential purpose, and hence the land sought to be granted passes through the middle portion of the converted land, to which by giving publication in the State Gazette under section 68 and 68(5) of the Karnataka Land Revenue Act, in the interest of the general public, calling upon objections from the public, if any, no objections have been received. By imposing value as per rule, it can be granted. So therefore, there is a recommendation of the Tahsildar that it can be granted. Subsequently, my lords, this is dated 9th of April 2015. Subsequently, on 30th of September 2015, The Assistant Commissioner, my lords will find that at page 76. He reiterates what the Tahsildar says.
This is on
30th September 2000, sorry, my lords is referring to the Tahsildar's letter or the AC's letter?
Annexure D is on 9.
Annexure D is on
Yes.
9/4/15.
Yes.
Annexure E, my lords, the next reference is on
Yes.
30th September 2015. So the Tahsildar sends it to the Assistant Commissioner with his recommendation that it can be granted. The Assistant Commissioner reiterates what the Tahsildar says and then sends it to the DC. I won't trouble my lords reading it. It virtually reads the same. Page 76 running on to page 77. Only difference, my lords may kindly see page 77, just about 3-4 lines above the last paragraph.
They call it a canal here.
I'll read the entire thing. As per the report of the Tahsildar, I'm coming back to page 76, second paragraph. As per the report of the Tahsildar, land bearing survey number so and so, measuring so and so in total, after deducting Kharab to an extent of 12 guntas, the remaining 2.17 guntas situated at so and so village has already passed land conversion order. Vide is order dated so and so. In the middle portion of this land, Kharab, which is passing the said area, as per the sketch, also as per survey records, measuring 12 guntas, which is B Kharab, the area which is sought for grant by the applicant. In this regard, spot inspection was conducted and the said Kharab lost its character, unfit for cultivation. It is passing through the land which is got converted for residential purpose. And hence the land sought to be granted passes through the middle portion of the converted land, to which by giving publication in the State Gazette under section so and so the Land Revenue Act, in the interest of the general public, calling upon the objections from the public, if any, in the event no objection has been received, by imposing value as per rule, it can be granted as per the report of the revenue officer in this village. This is the addition. At present, the value of land per acre is rupees 1.8 crore and market value is about 2.2 crore per acre. In this regard, the proposal submitted by the Tahsildar along with all the records, the grant of land to an extent of 12 so and so situated, the report submitted with the entire file is submitted for your further action. So this is sent to the Deputy Commissioner. Only thing, he fixes the price. So per acre, the market value then was about 2.2 crores per acre. Then, my lords, there is one more communication in the middle at page 79 by the Water Resources Department, Minor Irrigation Department. This is short letter. I'll read that also, my lord. This is at page 79, Annexure F.
This is where they call it a canal. Yes.
The second, I'll read the entire paragraph. With reference to the above cited subject, in the letter referred with regard to grant of land to an extent of 12 Kharab, passes through survey number 12/7, situated in so and so, which was proposed. If the said port is granted, if there is any problem obstruction, about which after due verification, as per rule, to submit the clear opinion, it was sought in the letter referred above. The said canal at present lost its existence. Also, the water of the said area will not flow to the minor irrigation lake. Therefore, the said matter does not come within the limits of minor irrigation department. Further, the steps you may take, there will be no objection of this office. So the minor irrigation department also gives a no objection. Then, my lords, the Deputy Commissioner finally on page 83, Annexure G.
Yes.
Here again, he reiterates the entire recommendation of the Tahsildar made to the AC, made to him. My lords will note it's verbatim, almost the same. And finally, he sends the recommendation, my lords, to, my lords may kindly see page 85 or 85. I'll just read the last paragraph. Therefore, the land measuring 12 guntas, which passes through survey number 12/7, which sought to be granted by giving publication in the State Gazette in the interest of general public, calling upon the objections, if any, in the event no objection has been received, by imposing value. As per rule, it can be granted, about which your needful order is sought. The report submitted by the Assistant Commissioner and the Tahsildar, along with the same, the proposal submitted for your perusal. So now this is sent to the Principal Secretary, Revenue Department. So until now, my lords, every officer has said that this land can be granted. No, I'll come to that, mother. Then finally,
Recommendatory. It cannot
all
be
100%.
binding on the
No,
ground.
I'll in fact narrow down the scope. I'm only taking my lords through the facts. I'm on a very, very limited scope. I think the learned single judge's order, largely, my lords, I cannot possibly find fault with, but only on a limited scope, I'd like to make my submission. Now, my lords, what happened is that on 12th of June 2017, at Annexure P, considering the Deputy Commissioner's recommendation,
Hmm.
the principal secretary, this is important, Manoj.
Hmm.
Now kindly see the ground on which he rejects.
Hmm.
Page 121.
Hmm.
Once I read this, a lot will possibly understand what I'm limiting my submissions to. My lords has 121, page 121.
Hmm.
With regard to the aforesaid subject and references, your attention is drawn. The land bearing survey number 12/7, in which 12 guntas, again so-and-so village, and by discharging the same from public interest, for passing order to grant the same, the proposal dated 23/3/2016, in which it was sought wide reference, in connection with the said request, it is sought to submit the substantial report, a suitable recommendation. This is important. Ones. In this connection, the letter received dated so-and-so and the information of which is verified. The Karab land measuring 12 guntas of so-and-so village discharged the same of public interest under the Karnataka Land Revenue Act. My lords may kindly mark this, for which there is no provision provided under the said act. So the principal secretary forms the opinion that there is, even though I have received a recommendation, there is no provision under the act for considering this grant at all. And therefore, he says, I am directed to take the said land to the custody of the government. Now, this is dated 12/6/17. He reiterates the same, my lords, at Annexure Q, page 124. My lords will kindly see at 125, the last but one paragraph. The principal secretary reiterates that there is no provision provided under the Karnataka Land Revenue Act. And then eventually, my lords, on 19th of November 2018, once again he reiterates that. My lords will find that at page 130, Annexure S. He directs the deputy commissioner to take possession of the land. So therefore, my lords, the sole ground on which the recommendations, as the lordship rightly pointed out, of the officers below was rejected was on the ground that there is no provision under the Karnataka Land Revenue Act to even consider this grant. So the principal secretary, my lords, did not go into the other aspects, whether there are any objections from the public or whether it has lost its character, did not go into that. Simply at the threshold said, there is no provision to consider this, and therefore directed the deputy commissioner to take possession. Now at this stage, my lords, we approached this honorable court, and my lords may kindly come to the impugned order at impugned judgment at page 22 of the learned single judge. The discussion, my lords, begins at page 25. Paragraph 4, my lords. Having heard the learned counsel for the parties and having perused the petition papers, this court declines indulgence in the matter, broadly agreeing with the submission made on behalf of the official respondents. Admittedly, the land in question belongs to the government, and that is the reason declassification from public purpose is sought, that is to facilitate petitioner's consideration for the grant thereof. A Dutch jurist so-and-so, I'll skip that notice. If the government is the owner of the land, it cannot be compelled to part with the land or any part unless the law provides thereof. I'll just pause here for a moment. Not for a moment. That's why I read the prayer. Not for a moment are we seeking any sort of a mandamus to compel the government to part with the land. Then, my lords, paragraph 5, the vehement submission of the learned senior advocate appearing for the petitioner that section 68 provides for extinction of rights over any public road, street, lane, or path not required for the use of public, and therefore the government ought to have issued an appropriate order for extinction of such rights in respect to the subject land is difficult to agree with. Reasons for this are not far to seek. Firstly, this section is not applicable since it is not the case of the petition. The subject land is a public road, street, lane, or path. Secondly, the subject land has been described by the government as Hallada Jaminu, that is approximately to mean a dike or the like as specified in section 67, which is more generic qua section 68, which is species specific. That is any public road, street, lane, or path, which is the property of the state government. Thirdly, the government in its discretion does not agree with the petitioner that it should issue a notification under section 68 for extinguishing rights of public. The government, being the guardian of people and property, has a greater leverage in discretionary matters like this, and the courts cannot run a race of opinions with it. Now, this is important. Paragraph 6, the next submission of the learned senior advocate that the petition for the petitioner that under section 69 and 69A, the government and its officials named therein have the power to dispose of landlocked government kharab land is true. However, such a power is not coupled with any duty having a jural correlative that is a right in favor of any citizen. The text of these provisions specifically employ the expression may dispose of, and thus the discretion of the government is marked by its enormity. I'll stop here. Now, this is all my submission is. if, my lords, the learned single judge noted that section 68 does not apply, I don't have an argument with that. But having noted that there is a power, I ask myself, my lords, does the learned single judge not disagree with the principal secretary's opinion? Principal secretary says there is no power. Learned single judge says there is power. Of course, I can't expect this honorable court to compel them saying execute any sale deed or anything by employing this provision. But I ask myself, would not the appropriate remedy then would have been to set aside the principal secretary's order saying, consider, now I have held that there is a power under section 69 and 69A. Learned single judge agrees with the learned senior counsel of the petitioner that there is a power. But he then goes on to hold that I cannot compel. I'm not asking for compulsion, which is why I brought my lord's attention, to draw my lord's attention to the prayer to consider my application. Now, up to a certain stage, there were recommendations saying it can be done. The principal secretary says there is no provision. Now, the learned single judge says there is a provision. So that's all I'm asking for. If the principal secretary could be requested to reconsider in light of the opening part of paragraph 6, my remedy would be, my grievance would be addressed.
Difficulties in these
Yes.
issues. We sitting in this jurisdiction cannot request anybody for anything.
Of course.
We have to direct.
Correct.
And for direction, there must be a
Legal
a
right.
legal right
Absolutely.
available.
Yes, ma'am.
69, 69A
Yes,
is for landlocked government land
correct, ma'am.
and by public auction.
Yes, madam. Yeah, absolutely.
Is
That
the
is,
only-
that is 69A. 69, my lords, doesn't speak of public auction. My lords, what is the section 69? It refers to disposal of lands belonging to state government under section 67. If my lords could come back to section 67, it is not restricted to only public roads or paths. It speaks of roads, streets, lanes, paths, bridges, dikes. Section 69, my lords, may kindly see first.
All public roads, streets, lanes, paths, bridges, ditches, dikes, fences.
Correct, ma'am.
also
Now,
by et cetera, et cetera.
now it is marked as what the learned single judge noted as Halla the Jaminu, which is loosely translated as a dike or a water
Correct.
body.
Are hereby declared to be with all rights in or
Correct.
over the same
Vesting with the state government.
property of the government.
Absolutely, ma'am. Now, my lords, may kindly come to section 69.
Hmm.
The subject to such rules as may be made in this, behalf, the state government, the deputy commissioner so-and-so, may dispose of land or other property belonging to the state government under section 67 or otherwise for purpose of agriculture, industry or any other public utility and subject to the provisions of. So all I'm saying, my lords, is if there is a power, and your lordship rightly asked the question, what is my right? My only right is to have my request considered in accordance with law. But for the principal secretary to have at the threshold thrown me out saying that there is no power, there is no provision at all. If section 6.
Again, there is a problem.
Yes, madam.
For the purposes of agriculture, industry, or any
Public utility, correct,
and
ma'am.
subject to the provisions.
Yes,
It
madam.
can only be for agriculture.
Yes, madam.
Industry, or any public utility,
True, ma'am.
not for housing.
Not for housing, not for any other purpose, but at least all I'm saying was having placed my matter before the principal secretary, my only legal right was to have my request considered in accordance with law. If he were to reject, as your lordships pointed out, that you are using it for a non-public utility, I will not grant it. I may have to work on my remedies or swallow the pill. But to say that there is no, that's all I'm on. And then, my lords, actually what the learned single judge then notes is, in the statement of objections filed by the state in the writ petition, in the underlying writ petition.
Just a moment. There's
Yes.
also another problem here.
Yes, ma'am.
69A says notwithstanding anything contained in section 69 and subject to such rules as may be
Correct,
prescribed
ma'am.
in-
Correct.
on behalf.
Yes, my lord.
The state government or the authorized officer may dispose of valuable land or other
Yes.
property belonging to the state government under section 67 or otherwise.
By public auction. Correct, my lord. And then provided further that landlocked government kharab in city areas up to 18 kilometers, once again by public auction. So if, my lords, if they want to do it by public auction, at least I
Therefore,
can.
there is a specific provision
Yes, ma'am.
with regard to landlocked government kharab in
Yes,
city areas up to 18
Correct.
kilometers, which you would fall within.
Yes, ma'am. I
If
would.
that is so,
By public
it has
auction.
to be by public.
Very
auction,
well. At least
by
let them
no
do
other
that, my
means.
lords. I'll participate. I'll participate because frankly, my lords, this land is not of any value to anyone else. It's completely landlocked. I own the adjoining property. it's, if they were to put it public auction, at least I'll have,
That landlocked argument also,
Yes.
from the sketch that is available in the file, it's not landlocked, there is a road.
yes, ma'am, but when I say landlocked, all I'm saying is, ma'am, it's possibilities of,
ways.
very
Three
well, if they put it to public auction, I'll participate. At least I'll have an option of bidding for it.
There again, the issue is, there is no compulsion by
Absolutely.
any route on the
Absolutely not.
government to
No,
do so.
all I'm saying, my lords, is if there is a request that I've made and there is a recommendation to grant, I can't possibly come before this honorable court and say that the principal secretary had no option but to grant it to me. But at least, my lords, to have my application considered in accordance with these provisions, that's all I can ask for, and that's all I am asking for. If they apply section 69A, that's fair enough.
Vikarab land is a government land which is kept open for the public purpose. That cannot be granted at any point of time to any third person for any purpose, my lord, within the city limits. Don't have any right to ask for the grant of such land, my lord. It's a public land.
Absolutely. So do
Request
you
to dismiss the,
Do you want to auction it in a public auction, or
No.
what do you intend to do with it?
it will be kept open, my lord. Kept open. Will not, no public action will take place to that effect, my lord.
Is for them to take it forward. And so, if they are already taking it forward, if they don't want to exercise.
One 35, hello? 134, 134, 135, 136.
This is from principles of the this leadership means from principles of the they can't forward, but it is signed by the but again.
Last page on the process. It actually one kare idiದ್ರೆ problem ಇರ್ತಿಲ್ಲ. Pursuant to section 69A, my lords, rules have also been issued that my lords will find at page 134, 135 and 136, where they've made, because the provision says subject to rules as may be made, the rules have been made. So the government does intend to do it, whether they want to do it in my case or not, let them consider, my lords. If they, all I'm saying is, my lords, they can't supplement their reasons as held in Mohinder Singh Gill, that in statement of objections, why they don't want to do it. If the order was there, at least I would have had an opportunity to challenge it. Let them say why they don't want to do it, why they do want to do it, very well. But at least I can have my remedies worked
Show
out.
us how they are compelled to give reasons.
They're not compelled. Absolutely not, Manoj.
Which is
But
why I'm saying compelled to give reasons. You don't have, they're not compelled to give reasons.
compelled to give reasons, Manoj.
Reasons.
No, when I,
Even for reasons, for saying that it is Bikara
Yes.
land, it belongs to us.
correct.
It is the government land. Where land is concerned, it's
Yes,
a
ma'am.
question of whether they want to divest themselves
Correct.
of it or not. Suppose, whether it is usable, whether it is not, whether they
course.
want to. If there is a rule which says that if an application is filed,
They're not,
it
yes.
shall be considered and an order shall be passed, either yes or
Yes.
no. Then you can say that the reason why they're
It's not a
not.
quasi judicial act at all. It is a purely administrative act.
Absolutely.
Yes.
Therefore, there is no need for the government to state any reasons.
No, Manoj,
All they have to say is whether
don't-
they want to,
Yes.
whether they want to divest themselves of their right over
Yes.
that act to you or to any other person or otherwise. They say they don't want to.
But on an erroneous ground, my lord, which the learned single judge has taken note of. That's all.
Should we exercise our jurisdiction in such a case is the only
To
question.
reconsider is all I'm asking for. If they once again say no, then well, I mean, I may have to, as I said, I accept it and move on. But now, whereas having rejected me on what I would submit is an erroneous ground, which has been noted by the learned single judge, I shouldn't be left remedialess. That's all my limited argument is. Which is why, and considering the fact that also there are repeated recommendations, so it's not as if the state government has constantly taken a contrary stand. In fact, up to an extent, they did support my case. And the government eventually said, even though I may agree with you, I don't have a power to do it. So possibly, my lords, they may consider, they may not.
2015 application. Now, suppose the government grants you this land at the 2015 rates.
No, I'll have to pay at this rate, of course. I don't think, if I can afford it, I'll pay it. Otherwise, there ends the. It cannot be.
What you're calling for may be to your detriment. There is now a big Harab land,
Yes.
admittedly within your property.
Correct. Now there's also a direction to take possession of it. I have been in, at least to that extent, there's a positive. Now my application I sought for.
Penalty may be this. Now, the fact that it's a big Harab, there
Yes,
is
It's undisputed.
absolutely no
It's undisputed.
doubt
No one can.
regard to that. Now, if we say that your application can be considered,
Yes.
probably the only way it can be considered is by conducting a public auction.
Well,
From,
very well.
from
Then
what it appears, that is the only.
possibly.
It may lead to a situation where somebody else buys it in auction and you're left with a situation where there is a
That's a risk I think on instruction I'm willing to take.
There are hundreds of acres of big Harab in and around Bangalore, my lord. Their opinion cannot be considered. It's kept open for the public purpose.
where is
From day one.
where is your objections in the statement of objections before the learned civil judge?
My lords, I'll find that as page 137. Yes, 137.
Kallada Jamin, Kallada Harab. Low-lying areas.
137.
When raining takes place on the land, water cannot flow. in the
Correct,
natural
137.
course. In the said portion, which is a stream, low-lying area compared to physiological structure of the land. What I can say that, as of now, I don't know. What government is doing, something on it, in fact, it is not. I think you see that government should divest itself of this, if they start saying that it's repetitive. From that position, maybe we can say that we can maybe make a fresh application or something, because the danger is this, if we say that his other application is to be considered. Okay, if it considers that it is considered on the basis of the application and land value is fixed at that stage. That also is dangerous. In a case where we are not convinced, why should we interfere as well? Thank you.
RA has given a report, my lord. That is at page number 146. That cannot be granted. And translated version is at page number 147 to 149, my lord. Page number 149, my lord. As per the aforesaid government order dated 23/10/2018, the land in question bearing 12/7 measuring 12 guntas of Karab already taken into the custody of the government. I came to know that the appellant at present approached the Honorable High Court of Karnataka by filing a writ petition number so and so, seeking a direction to concerned department for grant of land related Karab disposal notification in survey number 12/7 to an extent of 12 guntas of Karab. Karab pit. That is a report given by the revenue inspector of that locality. That cannot be granted.
Is there any separate notification issue?
Huh?
Separate notification issue?
Yes, my lord.
Illegal.
Page 142, page number. My lord.
Like 2020. Unlocked government lands excluding streams. Rate for Kharab land falling within agricultural land shall be fixed at guidance value of the surrounding agricultural land. The rate for the Kharab land falling within converted land but without a plan approval shall be fixed at guidance value as prescribed by the Central Valuation Committee. Rate for Kharab land falling within converted and approved layout shall be fixed at guidance value square feet. Provided further, landlocked government Kharab land in city areas up to 18 kilometers from limit of BBMP, up to 5 kilometers from limits of other city corporations, after extinguishment of public right under section 68, may be disposed of by the government at such rates specified in item 7 of the table, but not less than market value. Provide also lease 15 years to society, so and so, and shall be disposed of by government after obtaining report that land is not required for the government as a one-time measure prevailing guidance value.
Notification is dated 2020. Yes, Vikram, we will give you the liberty to file fresh application as per the notification till 2020. With that observation, petition dismissed. Yes.
Yes. Did you finish first one? 32 is first one? Huh. Can be. When council appearing on either side seeks a short accommodation, the staff changes.
7-4.
Just one moment. This one, 230 matter, the compromise petition has been sent to the other bench. Just Zadia is inquired. Yes. Who appears against you? Can be disposed of. Already been disposed.
ಯಾವಾಗ ಡಿಡಿ ಹಾಕಿದೆ ಗೊತ್ತಾ? ಯಾವತ್ತಾಯ್ತು ಹೇಳಿ? ಗೊತ್ತಿಲ್ಲ. ಈ ಬೆಂಚಲ್ಲೇ ಆಗಿರೋದಾ? ನೋಡಿ query.
B3 now. 325. Hold on. B3.
How much is that? How much is that?
Made up.
Same on only the details are.
Disposed of. ಇಲ್ಲ ನಿಮ್ಗೆ ನಮ್ಗಾಗಿರೋದು ಇವತ್ತು
ಹೌದೌದು dismissal ಆಗಿದೆ ಅಲ್ವಾ ಅದು? Disposed of same disposed. Four ಕೂಡ disposed of ಅಂತಲೇ ತೋರಿಸು. Same disposed. Disposed. ಅದು disposed.
ರಿಲೀಸ್ ಆಗಿದೆ.
Final hearing, number 24. Hanmantappa A. Sudhakar P.
ಏನ್ ಬೇಕಾ? ಆಯ್ತು ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಮಾಡ್ಕೊಂಡು ಆಯ್ತು 2 weeks time grant. Very good.
26. Udita Ramesh.
2 weeks ಕೊಟ್ಟು. ಹೌದು
Who sir? ಮಾಡ್ಕೊಂಡು
ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಮಾಡ್ಕೊಂಡು ಬರ್ಲಿಕ್ಕೆ 2 weeks. ಅಲ್ಲ ಆಯ್ತು ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಬೇಡ ಹಂಗೆ ಹಾಕೊಳ್ಳಿ at the request of law counsel for the appellant re-notify ಅಷ್ಟೇ first week
3/6 sir. Date 3rd of June. 26.
Arguing counsel is submitted that arguing counsel is held up in other bench. Hence. Okay, ಎಲ್ಲ June ಅಲ್ಲ.
There's some agreement to the matter of litigation pertaining to 2007. All the parties are senior citizens themselves. And the respondent who has been held as the rightful owner of the property has not even been able to enjoy the property for a few days. And also the rent that is being deposited also is the amount that was calculated based upon 2015 when the appeal was filed. And also the amount of 25,000 is being deposited. While the area, the entire neighborhood's rents have increased to the amount of 50,000 per floor. And this itself is a bungalow, my lord. That also has to be considered. In view of the same, at least, if at all an order directly given to, in respect to increase of the rent being deposited.
When was the order passed, the interim order passed? We remember that this matter has been argued at least 3 times. And on all occasions, the appellant has been taking time. Yes, this contention that the matter is hanging fire for 10 years has been made earlier also. So what do you say about this issue of, if you need time to argue the matter, that is fine. Then the rent has to be refixed.
Only to the extent of modification of the interim order, my submission is that, my lord, just the instructions, sir. It's in the.
Have you filed an application for modification of the interim?
My lord, I shall. The order given of this.
If you're ready to argue on the next date, it will be heard on the next date. Otherwise, we'll consider that application for for enhancement of rent. Yes,
I'll file the application, necessary application.
yes.
Okay, the request of the counsel for the appellant. They notify the date good to be due. In the meantime, the counsel for the respondent is permitted to file any necessary application, sir. Application for. Application for.
Yes.
Date fixed, next week, that'll be.
Next week is
Not
not
next.
possible. Last week, second week.
Second or third week of April.
24th, 4th.
Great.
27. AV Gangadrappa.
Fantastic. No request on traffic. Some appears you notified after 2 weeks.
24, 4.
24.
28, adjourned, 29, disposed, 20, 30, 31, Nagaraja.
No representation.
31, Nagaraja.
31, the records are there. AGA was directed to secure the records. Are records available? 31.
No, my lord. Look into that one, my lord. Shumaga. A week's time may be granted. ಹೇಳಿದ್ನಲ್ಲ.
Where is depot? Rejected application. Consider the appellant rejected both respondent. Second respondent. The ping pong going this way and that. First appellant allowed, set aside, then again set aside, then again set aside. Concerned respondent is hereby directed to re-examine the claim of the petition respondent afresh in accordance with criteria laid down for the purpose of allotment. As on the date of inviting applications for allotment of retail fair price shop. Above exercise shall be completed within 8 weeks.
Records were produced in the repetition itself, my lord.
Hmm.
We'll look into it.
Another issue, it appears that there are several directions issued to you to, after demand, whether the matter has been decided by the revision authority or not.
And when a week's time, maybe granted, madam. I'll inquire and get back.
Yes, no appearance for the appellant, the learned counsel for the, learned AGA for the respondent seeks a short accommodation to get instructions in the matter and to produce the records listed. Give a date. 15/4. This was in the petition papers. It appears in 25, there is an order to make available the records. 29/1/2020. All the you're sure that the papers are submitted?
The department has shown the acknowledgement, my lord. They are produced in the repetition itself. Let me inquire, my lord.
Call for the writ petition papers.
Please, my lord.
32 urgent, 33 urgent, 34 urgent, 35.
No problem. It's joint request. Joint request. Last week.
28/4. 36, BB Patil.
Give a date.
June. 4th June. 36, BB Patil. No, we have filed objection to that IA. I appear for NHAI.
You've withdrawn your challenge to 28.5. Therefore, with the issuance of the final notification, this is KIDB. With the issuance of the final notification, the land stands vested in the KID.
Wherein the media contended from the beginning, they are contending that there is no award in so far as appellant's land. is
Not
concerned.
required.
No. Then they subsequently what they submitted that there is an award that which they particularly to the appellant's land. In fact, in 2018, when they have filed an additional statement of they have stated that they have not taken possession of the appellant's land and there's no award has been passed. That is
Question is not whether possession has been taken, award has been passed, etc., etc. All that you can raise in appropriate proceedings. Question is it vested land which has been acquired by the NHAI? If it is vested land already vested in the KIDB, then what the NHAI has taken possession of is KIDB land.
that vesting that the technicalities which have been added, and that is
Please take us to 28.4. 28.4, 28.5, KIDB Act.
today
28.4. KIDB Act.
state government feel by giving this notice of intention to acquire such land. If the state government is satisfied that this land should be acquired for the purpose of notification issue a declaration
Can we stop there for a moment?
Yes.
You don't have a case that such a declaration has not been issued. 28.4 declaration has been issued, admittedly. Now please read 28.5.
On the publication definition, section 4, the land shall rest absolutely in the state government.
That was your challenge. Now the challenge stands withdrawn. Therefore, once a notification is issued under 28.4, the land vests in the state government free of all encumbrances. There is no requirement for the award. There is no requirement for the handing over of the possession. That is the position. Therefore, now that the land is vested, then what has been acquired is the vested land.
Where the vesting once the declaration and 28.4 is issued, as per the act, what it is, that it vests. But while vesting, the procedure, what Pinnacle had argued at the other day, that when there is, once the land is proposed and once the land is to be acquired, if the KDB to deposit the compensation, which they haven't done, and what is
Now we are taking the extreme view,
yes,
subject of course to correction by the council in this matter. We are taking the view that once 28(4) notification is issued, the land vests under 28(5). It is vests free of all encumbrances. So once it vests, then what is your right to say that because the compensation had not been deposited by the KIDB, the KIDB depositing the compensation, what is the extent of compensation that you're entitled to? All those are different questions. Once it vests, then by the subsequent notification, it is now between the NHAI and the state government. The state government probably may not divest the vesting that has happened to it to the KIDB unless the amount is deposited. That is another question. That is between them. Now, once it vests, then your right is to seek compensation. Not to say that because the vesting is not followed by the due procedure, you continue to hold on. It is not the situation. That would have been the situation had 28(5) challenge been accepted. 28(5) challenge you've withdrawn. Once you withdraw 28(5) challenge, there is a vesting in the state government. And once that vesting is there, then the further notification is not your concern. Your concern is to get your compensation in accordance with the first notification, 28(1) notification, not under the notification by the NHAI. This is what we feel. The challenge must be first after establishing your right. Because if anybody were to challenge the NHAI notification, it is the state government. Because by that time it has vested. Your right is to seek compensation for your notification, 28(1) notification, no difficulty. You can seek compensation, you can say that it is not deposited in time, you can challenge the notification on all grounds, but that will not continue to the second notification unless you can show us that the land has not vested. Vesting is a statutory vesting.
Said that once it is vested. Now the question is that by vesting, there were some irregularities which the constant highlighted that you're also that in a next day of hearing you would convince your lordship.
Do you have a case that there was no 28(4) notification? Do you have a case that there is no 28(4) notification?
You cannot deny that it is there. Very much.
Then the other questions would be only whether they are entitled to compensation. And what is the quantum of the compensation and the cost. Then the NHAI notification cannot be challenged. If it is there, then you cannot challenge the NHAI notification. Is our preliminary view on this point. Milord, you cannot challenge the NHAI notification because you are no longer the owner of the property in that sense. It is vested free of encumbrances. Unless you can say that there is no vesting, you don't have anything residual to challenge the NHAI notification.
They have utilized the land and there is one condition they have done there. They had some mutual understanding between KDB and one stage they would say that actually they are understanding free of cost, they have given the land to.
Absolutely. The question is whether you have a right to challenge that at all. Because once the vesting happens, is it not for the KIDB and the state government to decide whether they want to give it free of cost to NHAI or otherwise? Now the amount stands deposited.
Milord, yes, Milord.
Compensation stands deposited.
Milord, I will just, Milord, there were two aspects, Milord. One, Milord, I mean, there were two notifications. That is what they kept saying, but it was preliminary notification and final notification. So there were no two notification, two acquisition. There were one. So preliminary notification initially 7,482 square meter was proposed for acquisition.
Hmm.
But final notification,
Hmm.
it was restricted to 2090 square meters.
Hmm.
And for that 2090 square meters, because 5,392.347,
Hmm.
that was the extent which state government assured us to give free of cost.
Hmm.
So final notification, we restricted it to 2090 square
Hmm.
meter. And for 2090 square meter, we deposited in writ petition the
Hmm.
compensation,
Hmm.
and that has been withdrawn by the petitioner. So for 2090 square meters, they have already withdrawn.
Just a. There is 2019. No difficulty. No difficulty. They could even take it up for section with regard to quantum difficulty. Yes. No, we'll hear you. Not in piecemeal. We'll hear this matter on some other day. When do you want it?
One submission. In respect of writ appeal 28 of 22 is concerned, I filed an impeding application. madam.
Who are you?
I am the owner of the property of 2 acres, 22 guntars.
All that,
Which-
that is title of the property.
My lord,
Title of the property. You'll decide it separately.
industrially converted land, we are running the industry, my lord, we are in the. position
After allotment by KADB.
No, no, my lord, before.
That we'll consider
Before.
later,
before,
along with the main,
After also. my lord.
along with the main, will
Please,
be
madam,
considered.
please.
Yes. List on. 2-3 weeks.
21-4.
Please see whether the. Only for first.
Bench ಆದ ಮೇಲೆ ಅಲ್ವಾ? After the meeting.
Government advocate, there is a further bench, separate bench at 2:30. And then again, this bench will reconvene for the past overs.
Hello.
Hello?
ಹಲೋ ಮೇಡಮ್ ಧಾರವಾಡ ಕೋರ್ಟಲ್ಲಿಂದ ಶ್ಯಾಮ್ ಬಾತ್
ಹಲೋ?
ಮೇಡಮ್ ಕೇಳ್ತಾ ಇದೆಯಲ್ಲ?
ಕೇಳಿಸ್ತಾ ಇದೆ. ಪೇಪರ್ಸ್ ಎಲ್ಲ ರೀಚ್ ಆಗಿದೆ ಅಲ್ವಾ?
ಮೇಡಮ್ ನಿಮ್ದು ಒಂದ್ ಸ್ವಲ್ಪ ವಾಯ್ಸ್ ಕ್ಲಿಯರ್ ಬರ್ತಾ ಇಲ್ಲ ಮೇಡಮ್.
ವಾಯ್ಸ್ ಕ್ಲಿಯರ್ ಇಲ್ವಾ?
ಅಗ್ದಿ ಸ್ಲೋ ಕೇಳಿಸ್ತಾ ಇದೆ.
ಹೌದಾ? ಹೇಳ್ತೀನಿ ಬಿಡಿ.
ಮೇಡಮ್
ಓ,
ವಾಯ್ಸ್ ತುಂಬಾ ಸ್ಲೋ ಆಗಿ ಕೇಳಿಸ್ತಾ ಇದೆ.
ಮೊಬೈಲಿಗೆ ಮಾಡಿ ಹೇಳ್ತೀನಿ.
ಮಾಡಿದ್ರೆ ಇವ್ರು ಇಲ್ಲಿ ಕನೆಕ್ಟ್ ಮಾಡೋದು ಅಂತ ಹೇಳ್ರಿ ಅಂತಂದ್ರೆ ಅಲ್ಲಿ ಟೆಕ್ನಿಷಿಯನ್ ಫೋನ್ ಮಾಡಿ ಹೇಳ್ರಿ. ಅಡ್ವರ್ಟೈಸ್
ಮೇಡಮ್
ನಮ್ದು ಲೈವ್ ಇದೆ, ಏನ್ ಮಾತಾಡಿದ್ರು ರೆಕಾರ್ಡ್ ಆಗುತ್ತೆ.
ಎಸ್ ಮೇಡಮ್.
ಅದಕ್ಕೆ ಮೊಬೈಲಿಗೆ ಮಾಡಿ.
ಹೌದಾ
Good afternoon, brother.
Good afternoon.
You've received the compromise application?
Yes, madam.
Sarvanas?
Only petition number 3 and 4 have signed this.
Who has signed only 3 and 4? No.
In fact, there are only 3 petitioners.
Petitioner number 3 and 4 are the, just a moment.
There are only 3 petitions, madam, but signed by 3 and 4. It's mentioned like this.
No, the, that is all right because they are just withdrawing the writ petition, right?
Yes, madam.
So if we're receive further consideration. Where is that? Joint affidavit is here. That does not say anything about any.
Hello, there's surplus amount with the bank. We were prepared to refund it to the auction borrower anytime.
Then all that has to come on record.
They haven't served us a copy, my lord. My lord, we are not made a party to this affidavit. They are not served us a copy. They haven't said anything about the refund to be mentioned in the joint affidavit, my lord.
Withdraws all claims and contentions relating to the auction proceeding as against respondent number 3 and the property in question. And therefore, if this is being accepted, yes, there you are. Yes, so
Lords.
this can be accepted, your petition
Lords, now,
aims on that. What else? What
Lords,
further?
the bank, my lords, holds money in excess of what was recovered by auctioning the property. And about 53 lakhs 45,523 is what is held by the bank. But now the bank will have to refund this with interest.
My lord, we were prepared to refund the amount, my lord. They have not negotiated any terms. Yes, please, my lord.
Lords,
Not
it is-
approached that.
Willing to
Where,
refund whatever amount is in excess.
please, my lord.
The amount, are you aware or are you admitting?
We are aware, my lords. We have made submissions. We have given them a letter to come collect the amount
So
when the
Lords, they-
proceedings
that can
started.
also be,
Lords, the moment bank holds the amount, they become the trustees of my money and they are required to invest the money like as though it is their money. My lords, in all
My lord, it's Auction
circumstances,
proceedings, my lord.
where
It's auction proceedings. We sent them intimation saying that please collect your refunded
we
amount. They have
we
not
had our
approached us
accounts
till
there.
when was that intimation sent?
10 years ago, my lord, when the proceedings.
That has been done.
Please, my lord.
So where is the money?
It's with the bank, my lord.
Would it not,
My
earn
lord, we
interest?
sent them intimation. They have not approached us to collect the money, my lord. We were always prepared to refund the amount.
Apologies, I appear on behalf of the auction purchase.
auction purchaser is all right. You are now happy with the amount, they are withdrawing, whatever.
Lords,
Say that the amount will be, now that all the other questions are no longer available, we'll say that the amount will be refunded by the bank.
Lords,
my
if
lord,
it is-
we'll refund the
now-
amount, my
Now
lord.
this is something like this, my lords. It is because of what we calculated as the interest payable by the bank, we have agreed to this, my lords. Ultimately, your lordships have already expressed what is going to be the fate of this matter. But bank cannot be let scot-free for having done this because they are holding back the money. One is 53 lakhs, 45,000 and 523, which was intimated by a letter dated later of 2016. They had our SB accounts in there. They did not deposit. They held back the money. Notice, is it that do they want to claim that they were just holding this money in their pockets and not using it? This is the money which they have put in for transactions, 10-15% interest they would have earned on this. This is number one. Then we deposited 30 lakhs before the tribunal. There was also again a direction issued by the tribunal that even that 30 lakhs will have to be, the bank, respondent bank is directed to collect the pre-deposit lying before the registrar of this tribunal and deal with the amount accordingly as per law. So therefore, this is an amount which is held by them. They will have to pay the interest. Because if they had kept the fixed deposit, which would have been compounded today, 2016 to 2025, even at...
Brother, can you hear me?
Yes, madam.
Even at...
Oh, you are not audible.
Yes, I'm hearing.
You,
The senior counsel is not audible.
sorry,
Yes,
my
yes,
lords.
I'm hearing.
So, my apologies to my lords. So even if it is to be compounded on once with a term of 5 years, it would have gone to an interest of 12-13%, but I'm not asking that. Let them pay 7% interest and then
We can't decide on that question unless they are put on notice of this and heard.
Please, my lord, if
but so far as this issue, your lordships may take the
We'll just leave it open and say that the amounts will be refunded and any contentions with regard to that is left open.
lords, then because the whole object of settlement is to get a closure of the entire dispute, my lords. Let the bank may be heard on that, because bank will have to say, lords, in every case, my lords, where your lordships have directed the refund of the money by the bank, which is held in excess of the auction money, they have to pay it with interest. They have to act like a businessman.
my lord, if that was the case, they would have negotiated some terms with us and made us a party in this joint
Negotiation
affidavit.
with the
You
bank.
can't force us to pay interest, my lord. They would have,
No, they are using the money which is in their custody.
we would have refunded, my lord. If we were a party
No,
to
you
this
should have
joint
sent a demand draft to my address and then be done with it. If you're holding the money, you're holding the money. As simple as that.
we're always prepared to refund the amount, my lord. If we were made a party to this affidavit, we would also sign and saying that so-and-so amount will be refunded. if they want rate of interest, they would have negotiated the same with the bank.
If that were so, and if you were not a party to this, you,
We were, madam, but they haven't approached us regarding any settlement, my lord. With regards to refund, they have not approached us, my lord.
we'll do one thing.
Right.
We'll accept this and close it
Please.
as regards the two of you. And
Please.
with regard to the question of.
Only to that extent, your lordships may, please.
Leave the
Lords.
matter open.
Very well.
Please.
Lords.
What do you say, brother?
Yes,
Because
ma'am.
otherwise, the difficulty would be if this falls out. Ultimately, even this, with regard to the other issue. that-
will go.
Settlement
Correct.
will remain. My lords, I am assuring the court the settlement will
Correct.
remain.
It may be, my lord, my interest.
The joint application,
Because both
are defaulter
now.
joint. affidavit-
He did not take back the
Correct.
as per the request of the bank. And bank also may not have invested this amount in any other.
But then the bank, when it is in the custody of the bank,
Yeah,
we
mostly-
cannot think that it was not invested in any manner at all. Anyway, let's see. This joint affidavit cum memo filed on 16/3/2025 by petitioners 3, 4, and the third respondent
Please.
is taken on record. The, in view of the fact that the parties have arrived at an agreement with regard to the interstate dispute as between them. The joint affidavit is accepted and the writ petition and the auction
Lords, the challenge to the auction would not survive for consideration.
and the auction sale held and the auction sale of the property in question by the third respondent is confirmed.
Please, my lords.
The challenge as against the auction sale.
Lordships.
It will be recorded, my lord, in open court.
Just a moment. The challenge as against the
Okay,
auction sale is dismissed. However, it is submitted by the learned counsel, learned senior counsel, the payment of the amount of rupees 30 lakhs.
30 lakhs.
30
By
lakh.
way of demand.
The DD is recorded. The demand draft is handed over
Please, my lords.
in open court today. The numbers are all, there's no
Please, my lords.
Please, called out in.
the above view of the matter, etc., etc. The question with regard to refund of the amount collected in excess by the bank is left open to be decided. List on.
Next week, my lord.
Why don't you just make that submission so that we
Eh.
can,
Lords,
Any date, your
I'll
lordship.
file there are 2, 3 other judgments which I had seen. Wherever there is an excess money and the auction sale is not confirmed, is the bank is holding the money.
it is
Courts have
not-
directed 6% to 9%.
it is in the custody of the bank.
Please, my lord.
That it is not used for any purpose at all is, well, difficult. Anyway,
Please, my
list
lords.
next week for further hearing.
Great. Great.
List next week. Yes.
So grateful, my lords.
Against me, my lord, the repetition got it.
Yes.
Confirmed, yes.
Again, the sale is confirmed. Now it is only to,
Only for the
on
refund.
that other,
Interest.
if that had been worked out among you by now, even that could have been finished off by
Bank,
today.
bank is not agreeable, my lords. Otherwise, we would not have. Bank wants to stick to its stand that from 2016, they are holding back the money and they don't want to pay the interest. Definitely, they would have used my money.
Anyway, let's,
Let the bank take instruction. The council may take instruction, madam.
yes, council, please
Please.
get instructions on this.
Please, my lord.
That you had the money in your custody, whether you had used, if you had been using it for any purpose, unless you say, wherever you put it, does it not earn interest is our question.
Lords,
Even if it is
two-
kept
two
in the SBI
components,
account
my
also,
lords.
they are entitled for interest.
Lords,
Let's see.
2 components. One is that 53 lakhs. The other one is the 30 lakhs which they have taken from the tribunal, which we had deposited, made a pre-deposit,
Please
both.
file a memo. So
Memo
that,
of, yes, my lords.
please place it on record so that
Please.
we can. Yes.
So grateful. my lords.
Thank you, madam.
Thank you, brother.
ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಬೇಡ.
Passed your matter? Number 8.
Yes. You want to argue 9 first?
Yes,
You want
because
to
my
argue
lords.
9 for item 9 first?
Yes, my lords.
Yes.
My lords. Lords, I am asking this memo, my lord. And the other, my lords, like the council for the repeatedly said that they have not at all, nobody has surrendered the seat. I have submitted, my lords, the web hosted list of all the candidates who have surrendered the seats. It is web hosted on the KEA website itself. My lords, it starts from, my lords, may I kindly see?
Just a moment.
Yes, ma'am.
Yes.
My lords, after my lords, serial number 359. 9, my lords. Cancel seats as on 31/1. First, they have given clear vacancy, my lords. That is after the mop-up round. What are the seats available for the stray vacancy round?
Cancelled provisional seat matrix.
That is, my lords, those candidates who have surrendered, those seats have been given here. And again, as and when they surrendered seats, they have added, my lords. Kindly see, my lords, 359, again 388, that is also on 1st of February 2025, they surrendered.
This is as on 31/1/25.
21/5, and again on 1st
2/25.
and 3/2/25, and again 4/2/25, 5/2/25, and 6/2/25. This is for the, and again, my lords, 7/2/25, 10/2, and 11/2, 11/2. My lords, the last cancelled seat is on the 13/2.
When was the stray vacancy round held, as a matter of fact?
A stray vacancy round was held on, my lords, on 22, 25th is the result. 21/2/2020.
22 is the option entry had already been done. 22 is the actual counseling.
Yes.
22nd. And till 21, your contention is that seats were being surrendered.
Seats, more than 142 seats were surrendered, including the petitioners of petition number, writ petition number 4065, wherein my lords have directed that you have to surrender seats and then participate. Accordingly, those two petitioners also have surrendered, which are also there here in this list, my lord. The KEA statement that nobody has surrendered is a lie.
As on 11/2 is not paid seats. Some are surrendered, some are cancelled seats, some are not paid seats. All those have been put up on the.
These are all for the mop-up round.
For the mop-up.
Or the mop-up round. After second round, my lord, we start mop-up.
No,
round.
no, no.
Okay.
If anybody wants to come, they have to surrender.
Correct.
Surrender.
No,
they have
my lords,
surrendered.
my lords, may
Just a
kindly
minute,
see.
just a moment, please. Yes.
Now we are, my lord,
My lords, may
after the
kindly see.
mop-up round.
First title of the first page may kindly be seen, my lords. This is a continuous page numbering. 2024 provisional vacant seat matrix after the mop-up round. They cannot say it is for the mop-up.
PT 2024 provisional vacant seat matrix after mop-up.
Mop-up round. This is for the stray vacancy round. They cannot say that it is for the mop-up round. This entire, it is only one uploading, my lords, in the
So
website.
just a moment, when was the mop-up round held?
Mop-up round was over, my lords, on
The mop-up round would have been earlier because
earlier to this, my lords.
2848 is dated 4/2/2025.
Yes, my lord. 4/2/2025, and immediately they started it. I'll give the correct date.
Online stray vacancy round seat allotment 17/2. Can register now and apply online 18/2. Such candidates have to appear for verification, deposition. So it probably is correct because stray vacancy round happens on 22/2.
Yes.
So till then, after the mop-up round, everybody who has surrendered all the seats which are cancelled, then seats where payment has not been made, all that is made available.
Yes.
That comes for the stray vacancy round.
Before the sale.
Yes, now tell us. What
On
happens?
4/3/2025, my lords, the last date for filling up application for stray vacancy round. Accordingly, my lords, 4/2 was the order of this honorable court.
Correct.
My lords, may kindly see this, the for the stray vacancy round, my lords, I have already produced documents in my rejoinder, my lords, wherein kindly see, my lords, my rejoinder.
Just a moment, just a moment. Let's just go back to the prayer.
Yes, yes, yes.
What is the prayer?
Prayer is, my lords, mandamus directing the third respondent to notify the candidates to who part. Oh no, I'm sorry.
This is all the 148431 is R4. Correct?
Yes, my lord.
What is your rank, please?
My rank is, my lord, sir, 1,26,227.
Okay. Yes.
My lords, as per the,
according to you, the contention is that in the mop-up round, when you're moving to the stray vacancy round, this holding on business is not possible. It should have been given up and then the stray vacancy round ought to have been conducted. This is your case. Yes.
Yes, my lords. In the mop-up round, since one order was passed by this, my lords, that for 2848, that you have to send back all the all India quota students.
Correct.
And instead of redoing the mop-up round,
correct,
those seats, those who want to surrender, let them surrender and then participate in the stray vacancy round for those reverted seats.
Correct.
So around 64 or 65 seats were there and they were taken to a stray vacancy round, my lords.
64 seats were there. They were taken to the
stray vacancy round.
As also those who gave up their seats in the mop-up
round
were also permitted to participate.
Permitted. Your lordships in the subsequent order clarified very clearly in 4065 that those who want to participate in the stray vacancy round, they have to, if they are allotted seats, they have to surrender first and then they have to participate. Accordingly, my lords, in my rejoinder, I have also produced that the KEA on 15/2 has also web posted information that those who want to surrender can surrender and participate. That is at page number 17 of the rejoinder. Candidates who have selected PG seats in 2024 mop-up round and would like to surrender their seat can surrender before 4 p.m. on 17/2/2025. and such candidates be exempted from payment of penalty and all, and they can be allowed to participate. And thereafter, my lords, on 17/2, my lords, the web hosting was done. And again on 21/2, page number 19, my lords, clause C, subclause C, as per the orders of the Honorable High Court in WP number 2848, candidates who have been allotted in KEA mop-up round can participate in the stray vacancy round in the following rounds. This is what is the misrepresentation by the KEA, because, my lords, they should have again added one more sentence here. They have to compulsorily surrender as per the order of this Honorable Court in WP number 4065. Because, my lords, 2848 is regarding reversion of seats to All India quota, whereas in the second petition, my lords, your lordship directed to surrender. Very correctly in 15/2 notification, they say that, but subsequently they do not do it. And, my lords, the petition was filed by the KEA should have taken all the seats first. Instead of that, they allowed 257 candidates to hold the seats. My lords, my submission is this. On the other day, they said that there was no surrender. Whereas in DNB seats, they said they surrendered, the respondent. And I have produced, my lords, a copy.
EMB seat was different.
No, Ali could have surrendered. There was also surrender. There
EMB
was.
seat was in the, from the first round to second round and.
No. Same thing. Situation was the same. Yes, my lords.
57 candidates were permitted to hold the seat and participate in the stray vacancy round. Is your
They're also same thing. They're also same.
They're also same, but the round is different. Round was 1 to 2.
No, my lords. Mop up to stray. That is the reason, my lords, I was saying mop up to stray, my lords. Mop up to stray.
Anyway, yes.
My submission is, there also it is mop up. They say that here, no surrender. They also surrendered and they participated. And
participate in the stray vacancy round. Could not have been. Yes.
Yes, and, my lords, 257 candidates, my lords. Now, there were so many clear vacancy, cancelled seats, surrendered seats, all that was there in the list. These also should have been added in the surrendered seats or even in the list of all the clear vacancy. But they had not done that. They say that clear virtual vacancy round is done. My lords, they have not even taken all these for the stray vacancy round. What they have done is, those who are holding seats and they gave up the seats during the process and the next candidate was there, they gave it to them instead of giving it to the candidates who had entered fresh choices. Because the KE, as per the KE notification, all candidates were allowed to enter fresh options. And petitioner also has entered fresh option. It is not that, my lords, there was no rearrangement of any seat. All of them have done fresh entries except these 257 seats, which were wrongly withheld against the order of this Honorable Court. My lords may kindly see in the first and second round when I was requesting this Honorable Court that they should have at least disclosed first and second round. Not the stray vacancy round, my lords. Stray vacancy round holding is illegal. Even it is not there in the brochure also.
What does the brochure say about giving up seats in the mop-up round? There's no,
my lord,
concept
because of intervention of your lordships.
There is no question of giving up seats in the mop-up round in normal situations.
Yes.
It is only for the leftover vacancies that the
stray vacancy round.
There is no question of giving up. It is only because of the intervention that this giving up and the reconsideration, the stray vacancy happened.
Yes.
Therefore, when the court had said that they can give up within a particular time, they can give up and participate. That means give up and participate and nothing else. If they had not given up and participated, then that the merit gets a hit. Correct? Yes. So what is your answer?
My answer for that, my lord, I have filed a additional statement of objection. My lord. At the time your lordships have passed this order, my lord, the mop-up round, my lord, almost over. Mop-up round. In the mop-up round was the last round, my lord, for the, as far as regular, thereafter one stay vacancy was the last round. There is no contemplation of any other round. So mop-up round, my lord, was over. Now, my lord, the lordships are declared. Now, the lordships have not, my lord, quashed, my lord, the mop-up round results.
Because all those persons were
That
not
was,
on record.
yeah, if we would have quashed, my lord, we would have been in a better position. Entire thing, we would have redone it, my lord, immediately. Now, what had happened?
You may have been in a better position, the persons who participated did not have.
No, what happened? Because
Yes.
some students have already, mop-up round is the last round, they've taken the seats and joined the college. Many of them have joined the college.
Correct.
Therefore, my lord, I have given the, my lord, the numbers in my additional statement of the kindly. Para two, my lord, I'll read, my lord, though.
That is memo.
No, additional statement of objections. I have filed yesterday, I given to the court, clerk.
Just a moment.
Madam, then I put,
Yes, yes, sorry.
lordship, I just read para two, my lord. The respondent, after passing of the order in WP number 2848/2025 by this honorable court on 4/2/2025, initiated the process of implementing the order by eliminating the students who participated in the third round of all India counseling, who are also secured seats in the mop-up round of counseling held by this respondent. In that process, 61 seats allotted to all India participating students were removed out of total number of 946 seats allotted in the mop-up round. In the mop-up round, 946 seats were allotted, my lord. 61 all India quota, they went away, and 61 seats were available for the, for implementing your lordship's order. I can say so. Plus 885 students, that 946 minus 61, 885 who were allotted seats in the mop-up round they are also eligible to participate in the stay vacancy round.
If they gave up their seats.
That I'll come to that. I'll come to that.
This is the problem.
Yes, that's the vacancy round, as against 61 seats left by all India candidates, along with the cancelled and unfilled seats. Since the position as on that day, the stay vacancy round was the last round of counseling.
Correct.
A notification dated 21/2/25 to this effect was web hosted as per NHAI. It is submitted initially a notification dated 17/2/2025 was published for conduct of stay vacancy round as per Annexure R2, calling upon the fresh registration of candidates who have not registered with KE. Since this was the last round of counseling and all the available seats had to be filled up through KEA counseling as per interstate merit, and that the order passed in WPA 2848 was to be complied with to enable the students who are similarly placed in WP so and so provision for fresh registration. Provision was made for fresh registration, fresh option entry, payment of caution deposit, penalty clause for surrendering the surrendering was specified in that notification. 15th notification, but everything was there. Even surrendering was also there. However, pursuant to the order 13/2025, in WP 4065, the payment of penalty was exempted. Surrendering the seat by notification dated 15/2/2025. That is our. It is submitted with mop-up round. In the mop-up round, total number of 885 seats were allotted. Were allotted this seat. Out of them, only 275 students registered for their appearance in the vacancy round. The remaining 610 students have reconciled with the seat allotted to them in the mop-up round and have joined the respective colleges. These 275 seats, which were allotted to the students in the mop-up round, though not surrendered by them, I say, but they are not surrendered. They did not surrender. I straight away come to say, but it's not surrendered.
How could that have been done without
But
surrender?
because they don't run, the lordship kindly see, because they were not parties to any of these earlier procedures.
And my lord,
You were a party.
but my lord,
You were a party, you have understood properly on the 15
but
notification.
they have already allotted a seat. They joined the college
Correct.
and they were,
Those who wanted to participate in this stray vacancy round,
they would
they
have,
could have given up their seats and participated. Nothing stood in
they
the
would
way.
have run the risk of losing a seat also. That is the reason, my lord, they were not there.
There are more seats than are available. There are more seats than are persons who have participated available. There is no doubt there. Because at least 61 more seats would have been there.
But, no, my lord, seats, even now, seats go back in. my lord.
Not the question. How could you have, what is the provision for somebody who has taken a seat in the mop-up round to hold on to the seat and participate in the stray vacancy round? What is the provision? Apart from the 17-2 notification that you issued.
That swaps at the second round, because I should straighten the same.
It's wrong. It was incorrectly done.
Well, no, this is how they thought, my lord. Then we gave them the opportunity to, re-register.
Then what is the point in this court issuing directions specifically as to how it is to be done?
When the
Then if you're going to do it at your own sweet will and pleasure, then what is the point in coming before this court, considering these orders, considering your contentions, considering the difficulty of those persons who are not before the court?
My lord, in the second matter, my lord, in 4065, the matter was with regard to the, my lord, penalty.
Penalty again, you
Again,
impose the penalty, even though we said it should not be done.
Penalty was there, they would have surrendered, my lord.
The penalty was imposed in spite of our saying that penalty should not be imposed because it is not a case of voluntary giving up. It is because of this wrong thing that you had done. Everything steps, please understand that. Please understand that it is because of the of your action in going against your own brochure that the entire thing happens. Don't try to put the blame on the court.
No, I'm not.
It's not
For
the
a moment,
situation.
no.
It is only because you permitted persons who had already been allotted seats in the AIQ mop-up round to participate here without joining there, without surrendering their seats, whatever. Even if they had surrendered, they probably could not have participated here, going by the provisions. We don't know. Anyway.
They wouldn't have surrendered also, my lord.
They could not have. They could not have. Anyway, you permitted them to participate here. That created.
And showing these, their seats held by them, which has been, they have taken the seat as virtual vacancy.
Well, anyway, that was not in accordance with your brochure. You could not have permitted them, which is why this entire problem arose. That problem was sought to be rectified by saying that whoever wanted to, whoever was happy with their seat,
Yes.
they could just, that would have been the end of it. But if you were not happy with your seats, the specific direction was that you could surrender, and including the petitioners, those who had challenged, they were asked to surrender.
No, they were,
and participate.
no, they had surrendered and then filed the writ petition.
Whatever that be, the direction was that
Yes, that was not,
who had already been allotted a seat in the mop-up round would have to surrender and participate afresh.
Surrender was philosophy taking. Because this is how, my lord, they were thought. They were also eligible. Because putting these seats in the virtual vacancy, it doesn't make a difference. So that they may get the seat, they may not get a seat.
It does make a difference because somebody who has rank of 148431 has now been allotted to a seat, which was an option of somebody with a rank of 126227.
That, my lord, we have, I have explained in my earlier statement also why she did not get it. That, Your Lordship, can indeed take my statement of objection filed earlier. Why petitioner did not get that seat? Because there was somebody in between.
There would be nobody in between if it was shown as a vacancy instead of a virtual vacancy.
Yes.
There would be nobody in between if the seat was shown as a vacancy instead of a.
Except the petitioner, nobody raised a grouse about this process. Nobody has raised a grouse. Then once it is done, it is now boils down to between petitioner and the third respondent. Otherwise, my lord, we may have to redo the whole thing, but which is, my lord, the lordship knows is impermissible at this juncture.
That should not be a reason for you to flout your own brochures and the directions of the school as well.
The brochure, but if your lordship goes to the brochure, as far as stray vacancy round is concerned, no other candidate can come in. Who have already taken, nobody can come in.
Correct.
Even the petitioners also cannot come in.
Correct.
Even after, even if they surrender, also they cannot come in. Because, my lord, these 61 seats which ought to have been there in the mop-up round itself.
Please tell us who took the seat in the mop-up round, this specific
Out
seat.
of, that also I have said, out of this 275, my lord,
Hmm.
only 100 and odd, they have blood taken. That also I have said, because I made that distinction also. My lord. These, para 4 in the middle, my lord. These 275 seats which were allotted to the students in the mop-up round, though not surrendered by them, were shown as virtual vacancies to be allotted to the eligible students in the stay vacancy round on the inter-alia merit, and the same was published and web hosted as per NHAI R4. Thereupon, a consolidated matrix was also issued as per R5. Thus, the students who have registered to seek admission in the stay vacancy round had the benefit of choosing one, the vacant 61 seats left by all India students; two, the virtual seats allotted to 275 students in the mop-up round, and all unfilled and cancelled vacancies from the previous round. These are the seats available for stay vacancy. In the stay vacancy round, a total number of 720 seats were available for allotment. Out of that, only 235 number of students opted to take the seats. Further, out of these 275 students who were registered and opted to participate in the stay vacancy round, only 60 students have changed their seats. The rest of the students retained the seats allotted to them in the mop-up.
That exercise could not have been possible is the only thing, but whether something can be done at this distance in time, it's the only question.
Yes, you have wrong ballot as far as.
Blatantly wrong.
Yes,
There
yes.
is no
Yes, but
question there, it's wrong.
I
Could not have been.
literally accept ballot. You're wrong as far as surrendering is concerned. They have thought ballot, by putting it in the virtual vacancy, surrender may not have any ballot.
What is the meaning of us saying that it should be surrendered and participate?
That is how it is
Simply.
meant on ballot. I cannot improve upon it, ballot. Out of that, only 60 ballot is the. Out of that, only 60 students have taken, not all. Everybody went back. That means that where there's 610 students who did not come to the stay vacancy. Like that, my lord, except 60 in the stay vacancy, all reconciled to the earlier seats.
Yes. What is the statement of objection of R4?
But my rank is 1,48,430. Next year R2, that is 24 to 2025 notification. Earlier notifications also, Melos, 21 through 2025, which is there in the rejoinder statement. Where KEA Melos has very specifically notified a procedure. Procedure allowing candidates who are already allotted a seat in the mop-up round of counseling, reported to the institution, had made the payment of fees, are also permitted to surrender those seats. Also permitted to participate in the stay vacancy round by holding on to those seats. This was notified, my lords, on 17th and 21st second, and my lords again on 24th by KEA. Petitioners, my lords, are completely aware of this procedure. It is not as though, my lords, they have done or brought something which the petitioner did not. Petitioner was completely aware, my lords, the fact that if your lordships were to see 21-2, very specifically, my lords, if your lordships were to see 21-2 notification, my lords, I have not produced it, the rejoinder statement itself, my lords, of the petitioner. At annexure A, your lordships may kindly read that for me. Rejoinder, my lords.
Yes.
At my lords, in page 19.
That is 21.
Yes. My lords, point 2A, I'll read that. Candidates who have paid the fees and joined the college after allotment of seats in mop-up round should get registered themselves compulsory by paying 500 through online so and so to confirm their participation in the stray vacancy round. Such candidates will only be considered for stray vacancy round, and such candidates have already paid in the mop-up round and participated in stray vacancy round with new registration. They need not pay caution deposit, and such candidates have to enter the options afresh. Seat allotment in mop-up round will be considered as last option. If any seats gets allotted amongst the priority of options entered by them, they should report to the newly allotted colleges, or if seat is not allotted, the seat allotted in the mop-up round will be retained. If newly added options get allotted, they lose their old seat. If none of these seats are allotted, then the candidate's earlier seat is retained. Candidates are advised to participate in stray vacancy round with utmost care, and options should be entered carefully. Because this is a procedure not just for me, for the petitioner also. Petitioner was completely aware that there are candidates who are holding on to their seats and participating in the stray vacancy round. And that by notification, which I have produced, my lords, at annexure R2, in my statement of objections at page number 9, lords, virtual vacancy, that is also notified. And by a notification, the list of PG seats of candidates who are participating in the stray vacancy round by holding the mop-up round PG seats as per the options of the Honorable High Court, so and so is displayed on the website. These seats will be considered for allotment, stray vacancy round, in case if they get fresh seat in the stray vacancy round. Very specific, my lords, procedure is notified. If they get a seat in the stray vacancy round, these candidates, these seats, only then these seats, seats become real vacancy. Otherwise, it's a virtual vacancy. Procedure for such candidates to participate and whether those seats become available for everyone or not also is specifically notified. Well, I'll come to the aspect of whether it is right or wrong later, but the petitioner knew, because petitioner is not part of the earlier proceedings. Petitioner is only here participating afresh in the stray vacancy round.
He participates only in the stray vacancy.
Well, the petitioner in 6060 is not a petitioner himself, well, in any of the proceedings.
He participates only in the stray vacancy round.
Earlier, he didn't get, my lords. He
had participated in the mop-up, did not get participated in the stray vacancy, and now he's been allotted a seat.
my lords,
He has been allotted a seat.
no,
The stray vacancy.
no.
He did not get a
No,
seat.
no.
Well, so this procedure is notified. What, my lords, the petitioner committed a mistake, my lords, is I have shown afterwards. My lords, after this, my lords, I participate. My lords, I enter options at annexure R4. My lords, I have entered a total of 130 options. My option is at 77, which is the one that got allotted to me. 77, the code is M31 QC1, Dermatology at KJ Institute of Medical Science Management. Let's see page 21, serial number 77. Seat, my lords, was allotted to a candidate in the mop-up round of counseling itself. The candidate's rank, my lords, was rank number, my lords, 130977. Kindly note that. 130977. Petitioner's rank, my lords, is 126227. Above, my lords, this candidate who was holding on to this seat. And my lords, my rank is 148431. Here, my lords, very specifically, they have notified, even before participation of the petitioner, that this seat becomes vacant only if this candidate who is holding on to the seat at 130977 gets allotted as another seat. Petitioner is aware that this candidate is below him. And whether or not he would get this seat is dependent on his counseling, which is after petitioners, as per the notified procedure. Petitioner has committed a mistake, my lords, while entering only one seat as an option. It's a mistake committed by the petitioner, not applying his mind. If he had applied his mind as per the notified procedure, he knew that he will not be considered for allotment of this seat held by a student below in rank, unless that becomes vacant. Even in any case, that will not be allotted to him, because the candidate below him will become eligible. Oh, and that is only conditional, my lords. It is not a guarantee. It is conditional. Petitioner, having chosen to select only one seat, my lords, has committed a mistake. Putting all the eggs in one basket, my lords, is a mistake committed by the petitioner.
When was the petition filed?
Petition date, my lords.
Well, this I have explained in my statement, first statement of objection, in detail.
I have filed, petition is filed on the 27th.
When is, sorry?
27th of February, immediately.
Yes.
25th is the date of allotment. My lords, by 27th, my lords, I had made my fees, paid the fees. Allotment letter was issued. I have gone to the institution, my lords, and reported to the institution. At the institution, my lords, additional fees also is paid. That is the hostel fees and other incidental fees. I am continuing in the course of study. Another thing your lordships may kindly notice at this stage, my lords may kindly come to, my lords, Annexure R9, page 28. By now, my lords, second stray vacancy round is also both in MCC as well as in the state. My lords, next page becomes relevant, page 29. The entire process of admission ends, my lords, on 20th of March, 2025. If, my lords, for any reason I am sent out, I have no recourse, my lords. No recourse to any other relief, having already altered my position, having chosen as per the notified procedure. My lords, petitioner has not alleged any malefides against the authorities. Mistake, my lords, is one thing, but malefides is another thing. Only if there was malefides alleged against me, saying I was somehow in hands and gloves with the authorities for getting the seats, my lords, yes, petitioner can target my alone seat. Otherwise, the entire procedure, if at all, my lords, they had to be challenged. Well, petitioner being aware that that is the procedure, and if he was aware that it is in violation of your lordship's order, he should have come before, even before the allotment, because procedure is notified on 21st.
Yes.
One last thing, my lords, one last submission. My lords may kindly come to my options entry, my lords. My lords may kindly take option number 88. My lords may kindly note there. Option number 88, as per the list of allotment list.
Page number?
My lords, apologies. That's option number 88 is at page number. My lords, at 22 minutes. I have stated so, but kindly make a note, fellows. This is allotted to a rank which is lower than me. It was in my options. 88 is allotted to, my lords, 156623. This is allotted to somebody else. And, my lords, 170. Serial number 170. It is not reflected here, but I've stated in my petition, my lords, that rank number 153723 is allotted this seat. My lords, for these two seats, which are allotted to lower in rank than me, well, I would have been allotted here. If, my lords, any reason that the petitioner's seat was allotted to petitioner, I would have been allotted these seats. I would not be completely out of the counseling. Both are, my lords, again in Bangalore, MD dermatology and in Bangalore. Those very seats, same, my lords, price would have been allotted to me. Because I am the innocent student here, my lords, I cannot be held responsible, my lords, for the situation as my respective submission. My lords, kindly protect me is what I'm submitting. Please.
Yes.
My lords, a short reply to the respondents, this one, malefides, I do not have to, my lords, because it is, if it is a mistake by the KEA would have done it. They have Deliberately they have done it and they should have redone it. They have not done it. And continuously, learned counsel for the private respondent said that it is a petitioner's mistake. He should have gone by a virtual vacancy round is not correct, my lords, because I have applied my mind to the order of this honorable court. My lords, I do not have to, if at all I have to, then I have to go by what KEA says. But the KEA itself says in 15(2) notification that surrender the seats and then participate. Those who have already, they have so many who have surrendered the seats. These people also, even the respondent should have surrendered it. Whatever KEA says is not the order, my lords, it is the order of this honorable court. Because of the intervention of this honorable court, everything has changed. Otherwise, I would have not been there. Probably I would not have been there in the fray at all. That is a different issue. But because of this, fresh entries were allowed for the stray vacancy round. I have chosen 2 seats because, my lords, that was my interest. If I cannot, now if that is the case, the respondent's entry is at 77. From 1 to 76, it is only psychiatry. 77 is dermatology. And KEA has chosen to give her dermatology instead of psychiatry 1 to 76. They should have given that, my lords. And mine is first and second dermatology only. And it is my choice. My lords, I can give only one choice. I can give 100 choice. It is not respondent's will and wish that I have to fill my choices according to his will and wish. I can choose 1, I can choose 100. There is no limit at all. And if that is the case, then KEA should have allotted psychiatry instead of dermatology. Yes.
15(2) notification, KEA has understood it to be, they understand that they are complying with the lordship's order. To the extent that, whoever is surrendering, we are not going to be charging penalty to them, is what they are trying to say in the 15(2) notification. They have understood your lordship's order to mean that earlier, that was the subject matter of the writ petition, where students had come before your lordship saying, we've been imposed penalty. Your lordships have permitted students to participate, but they are imposing penalty of 2 lakhs. Your lordship said, no, don't impose penalty and extend the date for that penalty. Whoever you have given penalty also refund.
To surrender the seats.
I understand your lordship's language is clear, but they have understood it to be, my lords, in that fashion that it is only regarding imposition of penalty. 15(2) notification makes it clear that their understanding of your lordship's order is regarding penalty. Okay, whoever has imposed a penalty, we will give it back. We'll extend the date for surrender also.
Yes, what about the next 8? Item 8? My lords, next 8. My lords, it is pertaining to one prayer, my lords, wherein that is the reason, my lords. Issue a writ of mandamus directing the KEA to upload the seat matrix of the seats surrendered by the candidates who had been allotted seats in the mop-up round and who wish to participate in the stray vacancy round, my lords. Even in that matter also, my lords, the petitioners had asked, let them first surrender, then KEA has to notify.
When was that filed?
That was filed on 22 February, 22/2, my lords. My lords, none of the petitioners, either in the previous batch, they have not delayed at all. They have come, in fact, my lords. Honestly speaking, my lords, after I served this copy to Learned, as per your lordship's direction, served the copy to the KEA, that night the virtual vacancy round came up. Till then, it was not even published, my lords. 257 candidates who had withheld the seat. It was not even published. After surrender, the filing of this, it was served upon them. And then only, same night it came out. The list came out. Otherwise, it would have been a hush-hush matter.
Yeah, one thing I can assure your lordship, we are not interested in any particular seat or particular person. Only thing is, we must have faltered, my lord, as far as procedural aspect is concerned. We did not go by through as per your lordship's order. But the thinking was, my lord, since these 16 seats are fresh seats, that otherwise would have been available in the mop-up round itself for all. For all. Not only this 275, for everybody. So therefore, my lord, we asked if students of,
You treated the mop-up round as the second round.
yes. That is it.
Yes.
Lord, I did not hear. Normally, the problem with proceedings is I would have expected an apology from the KEA. The correct course of action would have been an apology from the, or expressing regret. Neither comes about, but a dismal explanation of the court's order to the court itself. And the mother of kindness that my lords are, let me put it, and I do not know how to harden this soul. With greater responsibilities, the soul has to be hardened a bit, my lord. That's what I would say. That's what I would say. Because getting away with 2 words, fait accompli, my learned friend said, otherwise 257 seats will have to be done all over again. So what? I'm saying we will not be doing it. That's not my suggestion also now to the court. I will also fall in line with the word fait accompli. The most shameless word in this judiciary. I'll only say this much to my lords, that fait accompli should never be countenanced by any court. I'll only say this much now. The KEA, for having violated the order of this court will have to penalize the KEA in the first instance. In similar situation, when such a thing happened, when it came up before the bench, they said it was only 5 lakhs. I'll make it 50 lakhs if you don't withdraw. These were the words, and we were watching there because we are interested in seeing how the law of damages develops in this country. It has not developed at all. We only do it as a chapter in our education. That's all. No penal action, no restitution, no improvement. Rajini case, they paid up 5 lakhs. The compliance came up before this court only, that they have paid up. Apart from the various adjectives used in that. So I will request 2 things to this court, my lord. Their order is a direct contempt of the order of this court and direct violation. Therefore, strictures be passed against the officer concerned, so that it has a salutary effect. I'm only interested in one part of the issue. Salutary effect on all officers, on all those who function, and all those who have to obey orders of this court. Last paragraph, my lord. And if not that, if it is to be interpreted that for any reason, as my learned friend tried to explain the against him for directly violating an order which was clarified by a second order. So either of the 2 things should happen to the KEA. Either not fit to hold that office, maybe some other office he can hold better. Therefore, it should go into his CRs. You're playing with one kid's life. You're playing with another kid's life. And you speak up, it is kind of ignored because you feel it's a bit excess. Doesn't matter, it will be repeated. There is yet another matter where there are strictures passed. So unless matters build up, there will be no reform, no change, no remorse, and no obedience to the orders of this court. And as for resolution of this matter, my lord, like we said about the other matter also, and there may be even serial number 8 may have a bearing, it may have a bearing on that also. The person with higher merit, now what happens? There's only one seat and we are in a situation like this. One candidate gets the seat. I leave it to the court which candidate will get the seat. Because sometimes it is, and then the other candidate can be put into the next year.
Yes.